Public defender.
Thank you. All right, so it's counsel in relation to Calexo Anaya.
Yes, Your Honor. Good morning. Chelsea Simmons for Mr. Anaya.
Thank you. So the case is 2002 1 CF 5940AO. It's going to Division 22. They had enough information to at least file the charge. He's got zero history, basically. So we're going to just probably set a bond unless I didn't see anything about PTR. Is that a factor, or is there a reason not? Or
Yeah, Your Honor, that charge doesn't qualify as a crime against a child.
I'm sorry, I can't hear you.
It's a crime against a child, so it
Oh,
doesn't
so that
qualify.
in and of itself. Okay. Any objection to just 1,500?
Your Honor, state would ask for a little bit more. State would ask for 2,000, given the nature of the offense, and that the child felt the need to escape.
Your Honor, according to the bond schedule, the child abuse third-degree felony carries a suggested bond of $1,000. We would ask for that.
Well, I guess, I might have been reacting to the facts also in regard to the 1,500. So I'll just leave it at that. It seems to be right in the middle of where you guys are at. So that's about right as far as I'm concerned.
Yes,
All right, so, and we have some standard requirements, sir, that no contact with the alleged victim's separate residence. Now, since this is a son, it means you might need to temporarily move out until you all can get to a court hearing and determine if it's safe. If you need a police escort to get some things out of the house, we can provide that. If you have any guns, knives, or weapons, you put those in the care of the arresting agency within 24 hours of your release, because you can't have any weapons while you're out on a domestic case. And, as far as contact with the son, sir, all court orders here will be consistent with orders by either the DCF or the juvenile court. So if you go over there, they probably did make them a referral and then determine that contact is appropriate, then these orders will follow those and be consistent. All right.
Your Honor, state would also ask for,
1,500. Huh?
state would also ask for the condition that he comply with any DCF investigations.
And comply with any DCF and or juvenile court orders.
Yes, Your Honor. And regarding the maintain separate residence, the child is currently in DCF custody, and Mr. Anaya works from home. He has a secure contract with the Navy where he has a specific setup at home. So I've already discussed with the state. He understands he has to maintain separate residences so that
If we just require compliance with DCF and or juvenile court orders, then we will be fine.
Okay. I just
Okay.
want to make sure he's allowed to go back home as long as the child is elsewhere.
Right.
Okay. Thank you.
All I said was separate residence and comply with DCF and or juvenile court.
Understood. Thank you.
Okay, thank you.
Have a good day.
You too. All right, is this Mr. Sierra Torres?
Yes, ma'am.
Thank you.
Interpret Your Honor.
Okay, thank you. Did we have more interpreter cases after that?
Yes.
Okay, okay. Or you just put them on top? Okay, thanks.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter.
Thank you very much. I think we have 3 cases for you. And the first one is Mr. Julio Sierra Torres, and that is 2021 CF 5928AO. And,
Your Honor, we have a witness.
okay,
Judging.
thank you. In regard to the public defender, if he makes that amount of money weekly, 600 weekly, he would not qualify. However, we'll appoint the public defender temporarily for the purposes of the initial appearance anyway. And if that's not a weekly amount that he makes, he should let us know, because we want to make sure he's represented if he needs to be. All right, so we have a witness here. Ma'am, could you raise your right hand to be sworn in?
I believe she also needs the interpreter, Your Honor.
All right, then, thank you. Corrections is saying that she needs an interpreter. So could the interpreter tell Mr. Sierra Torres, okay, he took his earphones off and, all right, then, over the intercom then, ma'am, would you raise your right hand to be sworn in?
Señora, levanta la mano derecha.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad, solo la verdad y nada más que la verdad?
Sí, lo juro.
I do.
Okay, ma'am, we have this police report saying that there was some potential for a domestic strangulation and battery, 2 charges. He doesn't have much history.
Bien, señora, tenemos acá este informe policial en que indica que hubo un acto de violencia doméstica, estrangulación, violencia doméstica y agresión física, violencia doméstica, él no tiene antecedentes.
Do you want contact or not while the case is ongoing?
¿Desea usted tener contacto con él o no mientras el caso está pendiente?
No.
No.
Okay, state's going to ask you some questions.
Good
Bien, la
morning.
fiscalía le va a hacer una serie de preguntas.
Good morning, ma'am. Can you please state your name for the record?
Buenos días, dígame su nombre, por favor.
Besaida Santiago González.
Besaira Santiago González.
Thank you. And what is your relationship to Mr. Sierra Torres?
¿Y cuál es su parentesco o relación con el señor Sierra Torres?
Teníamos una relación de pareja durante 7 meses.
We were a couple for 7 months.
Are you afraid of him?
¿Siente usted temor de él?
Sí,
Yes.
You already stated you do not want to have contact with him.
Y usted indicó que no desea tener contacto con él.
es correcto.
That's correct.
And do you believe drugs or alcohol played a part in this incident?
¿Cree usted que las drogas o el alcohol tuvieron algo que ver en este incidente?
Sí, el alcohol.
Yes, alcohol.
All right. Thank you, ma'am. That's all I have, Your Honor.
Gracias.
Now, I think you don't live together, is that correct?
Ustedes no viven juntos, ¿correcto?
No, compartíamos varios meses.
No, we used to share for a few months,
Okay, but not now.
pero ya no.
No,
Okay,
No.
No
Right.
questions, Your Honor.
okay, thanks. All right, then. So the point of that, sir, was to determine contact or not, and she doesn't want contact, and that's what we will order, no contact. That means,
Bien. Señor, el motivo de esa pregunta será para saber si ella quería contacto o no. Ella no quiere contacto, así que eso es lo que se establecerá.
no calling, no texting, no telling a mutual friend that she should drop charges or anything like that.
Nada de llamadas, mensajes de texto, enviarle mensajes a través de un tercero, nada de eso.
So I was thinking 1,500 and 100 because that's kind of standard in my mind.
That's fine, Your Honor.
All right, so 1,500 on the DV strangulation, 100 on the battery. Those
Okay.
are standard bonds, sir.
La fianza será 1,500 ante el cargo de estrangulación y $100 ante el segundo cargo.
The state's also going to request no alcohol while you're out on bond because maybe it keeps things a little quieter.
También se le prohibirá el consumo de ningún tipo de bebida alcohólica mientras se encuentre en libertad.
Your Honor, state would also request no return to the victim's residence and no weapons, firearms, or ammunition.
La fiscalía también quisiera pedir que se le prohíba regresar a la residencia de la víctima y que se le prohíba la tenencia de ningún tipo de arma.
If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. You can't have weapons while you're out on bond.
Si usted tiene algún arma, tiene que entregársela a las autoridades dentro de un plazo de 24 horas del momento que quede en libertad. No puede tener ningún arma.
No return to her residence.
Se le prohíbe regresar a la residencia de ella.
So make all your court dates and check in with the public defender, especially also about whether you financially qualify, because it's important that you're represented either by private counsel or the public defender.
Así que mantenga todas sus citas y todas sus fechas de comparecencia y comuníquese con la oficina del defensor público para ver si reúne los requisitos.
Okay, Thank you.
Your Honor, I
Gracias.
believe the witness has a question.
Yes, ma'am.
Diga, señora.
Yo necesito decirle, jueza, yo tengo una propiedad que es un vehículo que por la confianza que yo le tenía a él, la puse a su nombre, porque yo no poseo licencia de conducir. Quisiera saber cuál va a ser el estatus de ese vehículo.
I wanted to tell Your Honor, I have a property, it's a vehicle, and because of the trust that I have put in him, I have put the vehicle under his name because I don't have a driver's license myself. My question is, what's gonna happen with the vehicle then?
That, legally speaking, is considered a gift. Good luck with that.
Legalmente eso se considera un regalo. Te deseo buena suerte con eso.
I would never advise a person to do that. Good luck. Maybe he will be kind and put it back in your name. Maybe not. We lost the interpreter. Did you understand?
I'm sorry, Your Honor, the interpreter was connected to the podium for the new defendant that already has it on.
Oh, okay. So just tell her, I think she understood, but good luck because that's a difficult situation when you put it in his name. You'll have to get
Buena
him,
suerte, señora.
and you
Porque
can't
eso
even
es una
have
situación
contact.
difícil cuando uno pone propiedad a nombre de otra persona.
But what you really want is for him to deed it back to you. All right.
Thank you. Have a
Thank
good
you.
day.
And this is Mr. Cruz Barrow. Wait a minute. Okay. All right, sir, this is case number 2021-MM3434. Looks like I'm almost up. You might not qualify for the public defender's office, but I will appoint their office for now anyway to represent you. Check in with them in regard to whether or not you financially qualify. If you make that much money per week, it might be just over the limit of how much you can make and qualify for the public defender. Sir, today, the allegation is a domestic battery, and you don't have much criminal record.
Okay.
They do have enough information to at least file the charge. Since the other party is not here, we would require that you have no contact in separate residence.
Consideration, I believe Mr. Cruz Barrow has only been employed for a week. I don't know what monitoring situation is.
Would you speak to the microphone? Thank
He's
you.
only been employed full-time for a week.
Right.
Sit down and speak.
Yeah, it's just, a directional thing together
know.
with the mask. Yeah, if you sit down, it might be better. Thanks.
Thank you, Your Honor. I believe Mr. Cruz Barrow has been employed only a week full-time.
So, well, as far as the financial circumstances, I was going to ask if he qualifies for pretrial release, although it said no. I wasn't sure why, because there's not much of any history.
Yeah, Your Honor, he didn't really provide any information. He didn't give us a telephone number, an emergency contact, no email address. He couldn't even tell us the name of the company where he works.
Okay, so
Information.
what we could do is put either a monetary bond that's proportional or pretrial release if he ultimately qualifies, which means he would have to give them some information. I don't want to override the requirement that they have a phone
Lima
number.
Construction, la compañía. Lima Construction.
Lima Construction is the company.
All right, well, sir, what we'll do is we'll provide you the opportunity to talk to them again to see if you can give them enough information so that they can supervise you. Oh,
Does he understand what's required the information that's required to speak with
Este,
people?
well, I'm assuming if they have somebody who can speak Spanish with
Este,
him, and if he's calmed down, and
Uh-huh.
he's, been to court, and he understands it's important, then perhaps he can provide information. So we'll find probable cause, require no contact, which is what I was starting to talk about. It's important. You have no contact until both parties can be in court, and tell the judge it's safe. Also, follow any rules if there's a requirement from Department of Children and Family Services, because there was a child who allegedly was a witness to the incident. And so in regard to saying anything to the child, it's also depending upon.
Lo que pasa, su señoría, que yo me alteré porque
I don't
mi
know what he's
esposa se
saying.
fue.
You have the right to remain silent. Anything you do say can and will be played back at your trial. Please do not speak about the facts of the case before you have spoken with your lawyer about the advisability of speaking about your case.
Your Honor, in addition to the no contact with the victim, separate residence, they would ask for a one-time return with law enforcement. No weapons or firearms.
Separate residence, and you'll be allowed a one-time return with law enforcement in order to get some things out of the residence. And if you have any weapons or firearms, put those in the custody of the arresting agency within 24 hours of your release. Bond will be either 1,000 or pretrial release if you qualify after they talk to you again.
Your Honor, are you going to sell an alternate bond in case he doesn't qualify?
Yes, it's an alternate bond in case he can't provide enough information for pretrial release.
1,000.
1,000?
Okay. Thank you, sir. Good luck. Okay, and then we have one more interpreter case, I think. Okay, and this is Mr. Sagastume, case number 2021-MM3431, going to Division 61. Thank you.
Your
Yes,
Honor,
sir.
I do have an offer from the state,
Okay,
panhandling case.
right.
Mr. Sagastume has been on Social Security income for 29 years and panhandling at a county ordinance. The offer from the state is withhold of adjudication as well as credit time served. I didn't have a chance because of the Spanish interpreter. Could they explain that? Entering a plea that there's certain trial rights.
Well, I'll try to go over that with him. Does he have any reporting requirements?
He does, Your Honor.
Okay.
I don't believe I conveyed an offer. It's on any of the emails that I sent to Vince.
It was a
No,
city
counsel,
county.
I'm so sorry, but I really have got to ask
It's a
you
county
all to
ordinance,
speak
not a city
into the
ordinance.
microphones if you want me to hear you.
You can only do city offers?
Well, cities are withhold.
I assume. Okay.
1 second, Your Honor.
I apologize.
Well, what are we slowing down for? We got a ton of cases.
I misunderstood the offer. There wasn't an offer. This was a different, it's the county.
Be an adjudication, credit time served. Yes. It's not a city ordinance.
Apologize.
So you're reconsidering or it's a different?
Your Honor, I never conveyed an offer on this case. I think the Vince was confused. I think the city ordinance and those come.
Okay, so you don't do county ordinances?
Your Honor, I can plea out a county ordinance, but that is a state case. He was under the impression it was a city case and the offer.
All right, so, right, what do we need to get to, the bottom line?
It's an adjudication, credit time served, Your Honor.
Adjudication, okay. All right, I'll talk to him about that. So, Mr. Sagastume, if you want to resolve the case, would you please raise your right hand to be sworn in to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, my honor.
Okay, thank you. You can put your hand up. So, the recommendation or offer is that this be on your record as a conviction, and also that you get credit for time served and be released from jail. There are court costs applied or required, but we give you a year to pay that, or there's a suspension on your driver's license if you don't pay. It's important that you understand that if you give up the rights on the plea form and accept this charge on your criminal record, that if you are not an American citizen, you can be deported. And also, if you were on probation for anything, it would violate your probation. Do you understand those things?
Sí, yo soy ciudadano.
Yes, and I'm a citizen.
Okay. Now, did you see a plea form in Spanish, or have you seen that plea form before?
No.
Okay.
No.
Maybe we should give you a moment to read it, but we might need to have you sit down if you need a moment, because we have a lot of cases today.
Can you get a moment? Can
I
you be
was
recalled?
panhandling before.
Yeah.
Also, this is a panhandling case, which I don't like pleading to.
No, está bien.
Pull up your-
He says it's okay. Let me ask him. Sir, have you seen that form before?
No, es primera vez.
No, first time.
Oh, okay. Well, then, we probably ought to have you get a moment to read it. Sir, go ahead.
Okay.
We'll call you back up in a minute, but you're really entitled to read that thing. Okay, we'll call you back up in a minute. Just have a seat, relax, and read the form, and then we'll call you back up. So, okay, for our interpreter, we're gonna just call back in a minute, okay?
Not a problem, Your Honor.
Thank you so much. Okay, so is this Mr. Arevalo?
Yes, ma'am.
Yes, sir. All right, sir, this is, we have case numbers 2002-1 CF 5888 AO, allegedly Aggravated on a pregnant person, and also 2002-1 CF 5889, possession of something called tetrahydrocannabinols. And also, I think in on view, a violation of probation on a misdemeanor battery case, which is 2020 MM 817880. When you're on probation, the officer can file what we call an on-view probation, which is just basically to get that started, because it's going to happen anyway. If you have a new law violation, it violates your probation. So let's appoint the public defender to represent you on everything, so we can get that started.
I plead not guilty.
That's fine. Plead not guilty. However, we have to establish a bond for you and conditions upon release if you bond out. We know that you are married. We know there's some prior criminal history.
Your Honor.
Yes,
the
ma'am.
Defendant and the victim had a case that he recently pled to. There is a significant history of battery DV between these two. He recently pled to battery DV against the same victim.
Right?
So in regards to the bond on the agbat on a pregnant person, state would ask for $2,500.
The only reason I pled guilty on that is because
You have the right to remain silent. Anything you do say can and will be played back at your trial. And I recommend that you talk to your lawyers before you start talking about your cases. It's just dangerous for you to talk. So the problem about being on probation is that you're exposed to some jail time for that, getting a new battery while you're on probation. So I'm just going to go ahead and
I'm sorry.
put it at no bond on 2020 MM 817880. This means that your public defender lawyers will get you in front of the violation of probation judge, hopefully sooner than later. If they're looking at a no bond situation, they ought to call it up, bring it to everybody's attention and see what exactly is going on, what needs to happen in regard to that case. And in regard to the new cases, the Aggravated on the pregnant person, bond will be $1,500. Possession of tetrahydrocannabinols, bond is $150. No contact with the alleged victim, separate residences. If you get out on the VOP and you need to retrieve some things from the residence, you'll have a police escort, no drugs or alcohol that are unprescribed while you're on bond. And if you have any guns, knives, or weapons, put them in the care custody of the arresting office within 24 hours of release. So you have trouble on the county probation, but you're going to have to deal with it anyway. I'm just bringing it to a head right away. Yes, sir?
Is there any way I could get bonded out? Like for the,
On the probation, just talk to that judge. They'll look at it. You'll have hopefully a quick hearing. You can have a quick hearing on that. You can have a hearing within about 3 days. You'll have to deal with a weekend, and hopefully the public defenders are right on it. And they'll look at everything and probably get both parties into court and talk about what really needs to happen.
I feel like getting lied on, like she was lying on the, no, meaning on the.
Sir, I'm not going to hear from one side and make a different decision. I'm bringing the matter to a head, and you talk to that judge with both parties present.
10-4.
Good luck. Is this Mr. White's?
Yes.
Don't worry, if I raise my voice, it doesn't mean I'm upset for your case. It just means I was trying to get him to stop repeating himself because it was not going to change anything.
Yes.
2021 CF 5922, Division 14. We're going to appoint the public defender. And, sir, looks like we don't have a witness. So we order, as you probably know, the no contact with the victim until you get in front of the judge, and the judge hears from both parties and determines what it takes to make everything safe. And it says that you don't live together, but the state likes for me to also order that if you need to get some things out of the residence, then you can get a one-time police escort even if you don't live together. And you'll have no guns, knives, or weapons. While the case is pending, if you have any, give them to the arresting agency within 24 hours of any release. And I hope I don't have to worry too much because she lives in Miami. I was worried about your prior criminal history, sir.
Your Honor, the victim has a current Orlando address.
Okay. Sir, the best I can do is guess on these, but even though the threat to kill was conditioned on, unless she blocked the guy texting her, between that and there being, I guess it was a butter knife instead of a regular knife.
However, it also was also with a strangulation.
Right. I'm going to set the bond at 3,500 on the aggravated assault, 150 on battery by strangulation. Your history is concerning. So make sure you have no contact, even if you call or text her. I'm pretty sure you would be no bonded, so you need to just leave her alone unless you come into court and she says it's okay and a judge authorizes contact, just no contact.
Okay.
All right, good luck.
Thank you.
You're welcome. Is this Ms. Woodhead?
Yes, ma'am.
Thank you, ma'am. Case number is 2002-1 CF5737. I'm not seeing a witness step up yet. We have an alleged, it's Division 19, folks. And are you wanting a public defender? I didn't see a public defender.
No, I'm gonna get a lawyer.
Okay, so I've been informed that what they're doing right now is appoint a PD just in case so that somebody can get some things started for you. And if you substitute a private attorney, that's fine. The public defenders will just give that lawyer the information that they have started, but this process gets started faster
Yes, ma'am.
in case it takes you a while to get a private attorney. So, it appears that they have enough information to file the charge of burglary of a conveyance and the battery. This warrant is from an incident that allegedly happened on May 14th in regard to like pulling your girlfriend out by the hair when she supposedly was in a cast with a sprain, and there was a child that allegedly was a witness. So first thing is no contact, separate residence. Can't remember if you all were living together in this case or not, or if there was any information, but we'd say if you have to get some things out of the residence, we'll give you a police escort, so that'll cover it, whether or not you were living together. And in regard to the child, if there are any orders by Department of Children and Family Services or Juvenile Court, you would follow those, otherwise no contact. There's also an injunction in place, which I'm assuming might be pertaining to the same person. So follow any requirements of it, any pending active injunction. The bond on the car burglary charge would be $3,500, and the bond on the battery, given the fact that the $3,500 is substantial, will be a $100 bond. Not to minimize the battery, but the car burglary is a fairly significant bond, so we'll leave it at that.
Your Honor, state would request no weapons or firearms or ammunition.
And you put, I was about to say that, but put any guns, knives, or weapons in the custody of the arresting agency within 24 hours of your release. Thanks. All right. Is this Mr. Hernandez?
Yes, Your Honor.
Thank you. All right, sir, this is case number 21MM305AW. We're appointing the public defender to represent you. And Mr. Hernandez was out on bond, represented by Mr. LaFay, And just approved for a pretrial diversion on the 12th of May for a carrying concealed firearm charge. I did look that up. It was basically a traffic stop, the inevitable smell of cannabis, which seems to happen every time people get stopped and arrested. And then they supposedly found a pistol in there, so he was just about to be on pretrial diversion. That probably might get revoked, but, talk to your lawyer about that. As far as the pretrial diversion, but we have to deal with the bond situation also. Allegations were sufficient for a domestic battery to be charged in relation to allegedly pushing his sister while he was mad at his mother and family for talking to him about his life decisions. Sir, and there's a little bit of history. Now, because they're not here, we have to say no contact, separate residence for now, even though you're 19. I guess you'll be finding another family member to stay with in the interim if you get out. No contact until a judge hears from everybody and they can determine it's safe. Okay?
Yes, Your Honor.
If you need a police escort to get some things out of the residence, we'll provide that. Any guns, knives, or weapons have to be in the care, custody of the arresting agency within 24 hours of your release. You're not allowed to have any of those on in your possession while you have a domestic battery pending. So, I also noticed that it tends to be your mom who bonds you out. So, honestly, sir, when you're out on bond on a felony, it's really just common to be no bonded on that. But I know that your mom bonds you out generally. And also, I expect she's going to come in court and say, well, Judge, it's going to be okay, but, I just need some help. So, I'm ready to set a monetary bond on that if you want to.
Be out on bond, Your Honor?
Yeah,
State would ask that you revoke and double. Their original bond was $2,500. Your Honor, I understand your thinking
concerned
that the
about the
mother,
mom. Yeah.
the mother often does it. However, the mother doesn't have to. This is a crime by Mr. Hernandez. The mother can decide whether or not she wants to do that.
Well, not only that, she's hiring private counsel,
Yes, Your Honor.
So.
And a
you know,
firearm in conjunction with this
She
incident
doesn't have
is-
to. She
yeah.
can leave him in there.
Yes, Your Honor. So I just ask that you double it.
Okay. I respect that. I understand that. I'm just worried about the mom. So I'm going to revoke the one you're out on bond for in terms of the $2,500, and she'll have to pay $3,500 to get you out. I'm worried about punishing her. She's the one that would be punished for this. But what you need to understand is that you're about one hair's breadth away from being completely revoked and no bonded. But except that it's just like a pushing of the sister kind of thing, which I think you might have a chance to grow out of that kind of stuff. And so I'm not going to kill you on this bond situation, or your mom, who's the one who really gets punished. And on the new battery, it's $1,000. So it'll be $4,500 total, and just don't have any contact, or that could definitely end you right back up here in a minute, and that would definitely be on a no bond situation. So just leave it for a moment, let your mom decide if she wants to bond you out or not. And if she lets you sit there for a couple of days, well, maybe you think about some things. Good luck to you, sir. I raise teenagers too. I know it's a rough patch, but you probably grow out of it. Okay?
Thank you, Your Honor.
You're welcome. Good luck. Ms. Jordan, are you Jalen Jordan?
Yes, ma'am.
Okay, sorry.
Sorry.
I'm sorry, I was just looking at the name first, but I realized I know which case this is because I read it. So we got We got Mr. Jordan and Mr., what is it, English, back here somewhere?
Yes, Your Honor.
Okay, let me find that one, because I think it's back in the stack a little ways.
Last name Reynolds, Your Honor.
Last name what?
Reynolds.
Okay, thanks. Got it. Okay. So, the bottom line is a mutual, like kind of, I can't remember if it was pushing and shoving, but it's sort of in that realm of not being huge. And, I think Mr. Jordan might go back to New York or something. He's a college student. Probably qualifies for pretrial release. And Mr. Reynolds, I better barcode these case numbers. And so for Mr. Jordan, we have case number 21MM3437. And for Mr. Reynolds, we have case number 2021MM3438. And now we might initially appoint the public defender for both just because we need to get you through this original process. I don't think you've filled out the forms. Maybe you don't need a public defender because you might have qualify for a private attorney, but we just do that to get the situation started so you're represented initially. And then if you get a private attorney afterwards, they'll just substitute in, okay? So these are, not aggravated situations, just slapping kind of thing, but, so we're not too worried about violence. I don't think either one of you have any significant history. Although Mr. Reynolds has maybe a little bit here. So he might not qualify for pretrial release, but it's still a situation we can manage today. So we have you both brought in here. We'll get you sworn in, and then we'll ask you if you want contact with each other or not while the case is going on, okay? Would you raise your right hands to be sworn in? Swear to tell the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Okay, you can put your hands down. Now, and I would mention that since you both have charges, that you might want to be careful about talking very much about the facts of the case, because criminal charges, especially when, which one is Mr. Jordan?
Me.
Okay, so you're a full-time student. I don't remember hearing anything about that with Mr. Reynolds, but, if you're pursuing a college education and a psychology major and you're looking to get a professional license at some point, this is not the kind of stuff you want on your record. So don't say anything about your case, either one of you. Criminal records are not good for the future of your earning capacity. You have the right to remain silent. Anything you do say can and will be played back, because it's all being recorded to be played back at your trial. So try to not talk about the facts of your case. The bottom line is, do you feel safe? Do you feel scared? Do you want to see each other while you're out on bond or not? Okay? And the state likes to ask those questions. So she's going to ask first one and then the other. We'll make the notes, make the decision based upon what you want. But be careful about talking about the facts of your case. Yes, ma'am.
Mr. Jordan? Can you please state your relationship to Mr. Reynolds?
Boyfriend,
Okay. Approximately how long have you known him?
7 months, 8 months. Yeah.
Are you afraid of him?
Right now, no.
If you guys were both out of custody, would you be afraid of him?
No.
Do you want to have contact with him?
Yeah.
And do you believe drugs or alcohol played a part in this incident?
No.
Okay. Mr. Reynolds?
Yes, Your Honor. Yes.
What is your relationship to Mr. Jordan?
My boyfriend.
And you've known him approximately 7 months? Okay. Do you want to have contact with him?
Yes.
Are you afraid of him?
No.
If you guys were both out of custody, would you be afraid of him?
No.
Okay. And do you believe drugs or alcohol played a part in this incident?
No, ma'am.
Great. Thank you, Your Honor. That's all I have.
Okay. So any objection to the no hostile contact order?
No, Your Honor.
Okay, so no hostile contact is what we put down. You can have contact, but if there's any more fighting, then whoever is the one that's getting arrested that time, they also have a violation of release conditions on this case, which complicates release on any subsequent case. And So no hostile contact means no fighting, screaming, hitting, fussing, all that. Okay? And if you have any guns, knives, or weapons, put those in the custody of the arresting agency within 24 hours of your release. I'm thinking Mr. Jordan qualifies for pretrial release, am I correct?
Yes, Mr. Reynolds was never interviewed, so if you want to do a bond or PTR,
Okay,
State has no objection to PTR for both, Your Honor.
yeah, or just straight PTR for both.
all right, so Mr. Jordan, it's straight PTR means you don't have to post a bond because you got interviewed and they qualified you for pretrial release, but you do keep in contact with them. You can, if you're gonna move back to New York or whatever, you can do that, I'll make that order for you, but it's,
So he's the one that actually be moving back to New York?
oh, okay, so either one of you, okay, so it's Mr. Reynolds that I need to be specific, that if you wanted to move while you're on PTR, that you're allowed to.
Okay,
All right, but you still have to keep in touch with them and make all your court dates,
okay.
okay? So as far as Mr. Jordan, it's straight PTR. As far as Mr. Reynolds, it's either $500 bond or pretrial release if you subsequently qualify after you get interviewed with them, which I guess didn't get finished yet.
What interview with?
Well, yeah, they interviewed to make sure you qualify for pretrial release because they've got to have enough information to satisfy their criteria.
Okay.
And you have a little bit of criminal history, so it may or may not work.
Yes, from New York.
Okay. So that's it. Good luck. Make sure you make all your court dates. Is this Dustin McAllister? All right, sir. This is not working, okay. All right, sir, this is case number 2021-MM3411, and we're going to, you might not have qualified for the public defender in the long run. We're just going to appoint them temporarily to help you through this process. Not seeing much criminal history,
What's my
But-
first time?
and you don't have to say anything about the case, sir, because anything you do say will be played back at your trial. The allegation is violation of domestic violence injunction, and although the complaining witness is not here, she had told the officer that she's extremely afraid that you had just been served with the injunction the prior night. Okay, I'm remembering now. This was the grandmother, and the alleged violation was that you had parked right by her house and then went to a neighbor's to sleep because you have to go to work in the morning. And that you allegedly told the officer that, well, I didn't think it was a big deal if I just parked there. But she was freaked, and probably it was too close, because when you have an injunction, you're supposed to stay 500 feet away, and, so it's, you could say it's a technical violation, but it's also, but you could say that Dustin just, didn't think of it as a big deal, but now maybe he does.
Yes, ma'am.
Okay. All right, so no contact, abide by the injunction, separate residence. I don't know if you were already provided at one time, opportunity to get your things out of the residence,
Your Honor,
but,
that would be against the injunction.
did you looked at it, did he get a one-time opportunity to get his things out in regard to the injunction?
No, Your Honor, I mean, if an injunction is in place, then he's not able to return to the residence under.
All right, well, okay, so let's just say abide by the terms of the injunction. So we generally worry about you getting some clothes out of there, but I'm assuming that that's covered by the injunction. You have the right to remain silent. Anything you do could be used back at your trial. So just abide by the terms of the injunction, because I'm assuming they covered the issue. And, you know, so it says you're not qualifying for pretrial release because, for one thing, it's an injunction. So, you're young. I usually do a higher bond. I'm just going to do 1,000 because I think you're young and you thought the injunction was no big deal, but I think you might understand it now. Hopefully this works. Good luck. Make sure you come back for all your court dates. You're welcome. Is this Mr. Mejias?
Yes, ma'am.
Okay, thank you. All right, sir, this is case number 21MM3408. And it's an alleged domestic battery. They have enough information to at least file it. We're going to appoint the public defender to represent you. You do qualify. Sir, I understand that you're married, and I'm assuming that you live together, but until she comes to court, you can't have any contact. The judge would have to be convinced that it was safe for you to have contact. Assuming that you live together, I'll require separate residence, but a one-time police escort to get some things out of the residence pending having any court hearing about contact and living arrangements. If you have any guns, knives, or weapons, put them in the care of the arresting agency within 24 hours of your release. As far as contact with the kids, that's no contact unless until either Department of Children and Family Services or juvenile court specifies the conditions of contact, because they probably got referred a case. I can't remember if they were supposed witnesses or not.
They were present, Your Honor, but they didn't witness it.
Okay, so it might not be referred to juvenile court then. In which case, I should modify that to, I'm sorry, because you already wrote it down or checked the box. Okay, so it would be, contact is either through a third party to arrange visitation or custody exchanges, or if any orders by Department of Children and Family Services or juvenile court, those orders prevail. Okay. Now, I understand that it was a alleged throat grab, so it's definitely a misdemeanor case. I was concerned that you have an old violation of probation on an aggravated assault case in New Jersey, I think, but they're probably not going to extradite because of the distance. And there's some violence and drug history. So I was tempted to put a $2,000 bond on there instead of a $1,000 bond, being just out of concern and wanting to, just a little concern in regard to this history, sir. Good luck to you.
Thank you.
2,000, thanks. All right.
Your Honor, Sergeant,
Yes, sir.
it's mental health, but the victim is here.
Okay, thank you. That's case number 21MM306AW.
Your Honor, I believe the witness we have is just a witness, not a victim.
A witness, not a victim?
Yes, Your Honor.
Was she approaching the witness booth? I thought she was.
I thought
For
so as well.
another, defendant.
Excuse,
Okay, it is the victim.
oh, okay.
There we go.
It's her dad, supposedly, yeah. Okay. Yes, sir. Would you raise your right hand to be sworn in? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. We'll just ask you to speak up a little bit because I have trouble with some of this other stuff going on in here. So your daughter's 19. She would otherwise qualify for pretrial release. And then we might have, I don't know if it's better or not to think about mental health pretrial release because with mental health pretrial release, she gets some services maybe, unless she already has services. If you already have medical insurance and she's already getting what she needs, then we don't need to think about mental health pretrial release, but it is a possible program. It might actually take another day or two to qualify her, but it comes with services, medication, counseling, treatment.
Yes, ma'am.
Your Honor, may I inquire?
Yeah.
Good morning, sir. Can you please state your name for the record?
Kevin Sargent,
Okay, and what is your relationship to Kiana Sargent?
my daughter.
Are you afraid of her?
No, ma'am.
If she were to be released from custody today, would you be afraid of her?
No, ma'am.
Do you want to have contact with her?
Yes, ma'am.
If anything like this ever happened in the future, would you feel comfortable calling 911?
Yes, ma'am.
And do you believe drugs or alcohol played a part in this incident?
No, ma'am.
I know the judge was talking to you about mental health PTR. That would be releasing her without a monetary contribute. Like she didn't have to put any money down. Is that something that you're interested in?
Yes, ma'am.
All right, thank you. That's all I have, Your Honor.
All right, thank you. Sir, do you want straight pretrial release or do you want to see about mental health pretrial release, which comes with services, although it might take a little longer for them to screen her?
Pretrial release.
Okay. All right, I think that we'll go with straight pretrial release, no hostile contact. She's not here for us to tell her that, so hopefully you can just get her to read the court paperwork and try to help her take it seriously because she can't do any fighting or, you know, more of this sort of thing while she's out. And if she has any guns, knives, or weapons, she has to put those in the custody of law enforcement within 24 hours of her release, the same agency that arrested her.
Yes, ma'am.
And I'm sorry if you called trying to get help and they took her to jail and you really wanted her to be corrected, but this is what happens sometimes.
Yes, ma'am.
Good luck.
Thank you.
You're welcome. Okay, is this Mr. Thrower? Is this Calvin Thrower?
Oh, Scott. Next on the list is Scott Justin.
Oh, yeah, I was just looking at the wrong part on the page. I'm sorry. This is Justin Scott, 21MM340080. Let's appoint the public defender. We have a witness, ma'am. Okay, thank you. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. I just ask you to speak up a little bit.
Okay.
State wants to ask you some questions about whether or not you feel safe if he gets released.
Good morning, ma'am. Can you please state your name for the record?
Raven Hester Sims,
And what is your relationship to Mr. Scott?
my boyfriend.
Approximately how long have you known him?
About a year.
Has anything like this ever happened before?
No.
Do you want to have contact with him?
Yes.
Are you afraid of him?
No.
If you were to be released from custody today, would you be afraid of him?
No. We actually have a flight to catch at 6 today.
Do you believe drugs or alcohol played a part in this incident?
Nah.
That's all I have, Your Honor.
Okay, I mean, I saw that you were on vacation and everything.
Yeah.
And the only thing that got my attention was, let me check, there's an updated information sheet, but he allegedly, now I'm not sure exactly what these notes are kind of condensed, but
Okay.
out-of-state arrests include some little stuff, but also murder and attempted murder. Now, I don't know if that was completely bogus, because I don't see any convictions for anything.
Your Honor, it may still be open and pending, I'm not sure, since it's not our jurisdiction.
And false imprisonment as a juvenile. So I don't know if you know any of that.
I do. I'm aware of all of it.
Okay,
I've
all
seen
right. I
past.
just, when you say you're not afraid, I just want you to know
Thank you, Your Honor.
that there was an arrest. I don't know what happened to it or anything about it, but,
Right.
it might be relevant to how you feel.
Oh, no, trust me, we're good.
All right. Okay. Okay. Anything else, Counsel?
No, Your Honor, I just
So,
asked that you set a bond.
Notwithstanding those arrests, because there's zero history. Oh, okay. He used to qualify for PTR, but now he does not.
No, he doesn't qualify, Your Honor.
Okay.
He does or does not?
Does not.
Evidently does. I don't think did I appoint a PD? Because he's supposedly a singer and rapper, but I guess he's not famous yet because he qualifies for the PD. All right. And he's on vacation.
Say it again, I'm sorry.
But he supposedly has zero income, okay. All right, appoint the PD temporarily. All right, based upon all of it, let's just call it a $500 bond. Wait a minute, I'm sorry. It's at least $1,000 in case the bondsman has to get on a plane and bring you back. No hostile contact if you have any guns, knives, or weapons on you while you're on vacation. Put those in the care and custody of the arresting agency within 24 hours of your release. Make all your court dates, or else you'll have a nice little warrant hanging out here in Florida if you ever want to come back to Disney World.
So, Your Honor, you set it at 1,000?
Yeah.
Okay, thank you.
Where do I go? How does that work? Do I go down there
I
to
think
handle
you go
that?
downstairs and
Okay.
deal with it. Yeah.
And they give me the information, right?
Yeah, or a bondsman maybe or something.
Okay, thank you, guys.
Yep, you're welcome. Okay. All right, is this Mr. Thrower?
Yes, ma'am.
Okay, thank you. Sir, this is case number 21MM3446. We do have a witness here, and I'm not seeing a public defender application at the moment, and you've got Evan Self as representing you on the other case.
I'm on listen to. I don't know if he's supposed to call, or he said he's supposed to call y'all this morning.
All right, well, he might have had some other court appearances or something, you can't always get him in at a moment's notice. So, the allegations are domestic battery, assault, criminal mischief, I think. Yeah. 3-month relationship, and she's about to testify. He's out on bond for the possession of firearm by convicted felon in 2021 CF 3292. That's a $10,000 bond. And here's another one, ma'am, where you're going to tell us whether you feel safe or not, but he does have some criminal history of arrests. He's got 2 felonies, 3 misdemeanor, I think, convictions, but those were more like burglary, resist, and criminal mischief. But arrest history, some of that is like he arrested, evidently not convicted, for attempted first-degree murder with a firearm.
Twice, Your Honor.
And first-degree murder and possession of firearm by convicted felon and robbery, battery. So I don't know if you know about those things or not. If I were dating somebody, that would be relevant, even if it was only an arrest and not a conviction. It would be a relevant consideration. I just want you to know about those, because it might or might not affect how you feel. I'm not trying to trash your reputation, sir, but I'm just trying to figure out what's safe or not, and I think full information is appropriate. So, ma'am, did you want contact while if he gets out?
No.
I don't know, I wasn't trying to influence your opinion, was trying to give you information, and if you need a minute to think about it, that's okay.
Your Honor, I believe she said no.
State's going to ask you some questions about it. Did we get you sworn in yet?
No.
Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Swear.
Is that a yes? Okay, and then you need to speak up a little bit, because it's kind of loud in here.
Can you hear me?
Everything reverberates, thank you.
Okay.
Good morning, ma'am. Can you please state your name for the record?
Cheryl Newsom,
And what is your relationship to Mr. Thrower?
his girlfriend.
Approximately how long have you known him?
3 months.
Okay. Are you afraid of him?
No.
If he were to be released from custody, would you be afraid of him?
No.
Do you want to have contact with him?
I don't care. Yeah.
Okay.
Was that a yes or no?
Yes.
Okay.
Are you willing to call 911 if anything like this ever happened again?
No.
You're not willing to call 911 if
Oh,
he
yeah,
ever
I'm
threatened
sorry.
you again? Okay. And do you believe drugs or alcohol played a part in this incident?
No.
And has anything like this ever happened before?
No.
Thank you. That's all I have, Your Honor.
Okay. All right. Anything else? I mean, all right, she's done. All right, fine, okay. So we got two things to deal with. You're out on bond for possession of ammunition by convicted felon. It's a $10,000 bond. And you've had arrests for that sort of thing before?
Yes, Your Honor, I believe it was $5,000 on the possession of a firearm, and it was $5,000 on the possession of ammunition.
Oh, okay. I don't think I looked up that one, I can't remember, but, and part of what she was really concerned about was allegedly, and I'm not asking you to say anything about your case, I'm just kind of thinking out loud, and I don't even know if that matters to you, except, people probably wonder why judges are what they're thinking. And what a judge has to think about is what's safe and what's not safe. And firearms, having represented several young men for murder in the past, I just know that, firearms are dangerous. Things can happen, and I get worried about it. So you've got a bit of a concerning history. Makes me just wonder what, is going on. And the just repeated taking of her car is an issue of heightened concern. It's kind of like, you got control. You got to do whatever you want, So I'm just telling you, it makes me more worried.
You don't have to worry.
No, well, okay, you don't have to say anything about your case. I'm pretty sure Mr. Self doesn't want you talking on the record.
Your
So
Honor,
state's going to make a recommendation.
Your Honor, given the nature of the facts in this case, also there is an allegation in the affidavit that there is history that was non-reported by the victim on a previous occasion. And then given the victim or the defendant's history, state would just ask for a bond that's in conjunction with all of those things. His history is rather violent. And the victim, when she testified first, said she did not want contact. And then the second time when she was asked, I believe she said she didn't care. And then she said yes. So I would just ask for no contact with the victim, as the facts in this case are pretty violent and the defendant does have a violent history.
I forgot to mention that in the police report, that she'd said that he threatened to kill her if she called the police, but she called him anyway. So,
Yes,
I mean,
Your Honor.
she seems to be on the fence. She's over here, she's over there, she's like, and that doesn't mean that she's not credible. It might mean that she doesn't know what she wants, She really likes it, but she's also scared. So, that's not unusual, that's kind of human, right? So I have to figure out what's safe. And the only thing I can tell you, Mr. Thrower, is when you got stuff like you've been arrested for murder before, every judge who sees you is going to have the hair on the back of their neck standing up, especially when you carry around firearms periodically. It's scary. It's scary, okay? And I'm going to react as such. So, in the one that you're out on bond for,
Your Honor, state would ask that you revoke and double, which is standard in these kind of cases if you
yeah,
don't just
I
overall
was going
revoke.
to at least revoke and double. So you had the 5,000 on the possession of firearm, the 5,000 on possession of ammunition. Both of those are going to be 10,000. And Mr. Self knows what to do about it. He knows how to present the situation in terms of whether you're safe or not. The first appearance judge has to just be safe. And so as far as the, I'll order no hostile contact if that's what she wants. Are you sure?
I'm sure.
Because, the guy just takes your car.
I'm sure.
He just takes your car.
I'm sure.
And that is not exactly a good sign. That is a sign of control.
Your Honor, state would still ask for no contact, even with the victim's testimony.
Well, I've done this for a lot of years. I'm going to let her have what she wants right now. And the only thing I'm going to say to her is, ma'am, sometimes it takes about 6 times before you get real sick of it, but I'm just going to respect what you tell us you want right now.
Okay.
Because I'm afraid you're going to let him come around anyway, even if I order him not to. All right, in regard to the battery, assault and criminal mischief, it'll just be the kind of regular bonds on that. I'm a little more concerned about taking the car. If the state looks at this,
Your Honor, there is also a grand theft motor vehicle, but I don't believe the victim wanted to prosecute.
they haven't, well, that didn't come in on the paperwork. She
The
didn't want to
victim didn't want to
prosecute
prosecute
for
for it, which is why the
So
officer
here's
didn't
the
file the
thing.
charge.
Sir, I got sworn into practice 41 years ago. I've seen a lot of these things. This is the kind of thing that if she wanted it, it'd be a grand theft auto case too. It's more serious than I think you understand. So, but the battery, dating violence is going to be at 1,000, the assault is going to be at 100, and the criminal mischief is going to be at 100, the smashing of the phone, every single one of these things is an indication that he's going to do whatever he wants.
Your Honor, state would
Good
ask
luck.
for no weapons or firearms without a valid.
Any weapons or firearms have to be in the care and custody of the arresting agency within 24 hours of your release. Of course, you're not supposed to have any way while you're out on bond for possession of firearm by convicted felon. Sir, you can play this game for as long as you want, but there's going to be a point at which the door is going to slam behind you. And you're giving Mr. Self more work, a lot more work to do. He's a lawyer, he's not a magician. So you need to calm down. And don't mess with her, and don't just take her car whenever you feel like it. You don't have total control.
Yes, ma'am.
Not when you've got judges watching over you. Good luck.
Thank you.
Your Honor, next on the list is Leon Wright. He refused court, but the victim is here to speak.
Okay, I thought that might happen. All right. This is case number 21MM3447, alleging a battery and a domestic or violation of injunction. We don't have a public defender form filled out, but that might be because he couldn't do it.
Your Honor, may we approach?
Yeah. Oh, I can't hear anything. Got it, okay. And this is his mother, Ms. Turner, right?
Yes.
Okay.
Your Honor, may I inquire?
We'll get you sworn in to tell the truth. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I just want to say, I did look a little bit. I see that he's had multiple Baker Acts. You thought that the injunction in 2018 DR 1559 had been dropped or expired, but For some reason, that thing never got completely closed out. I'm just telling you right now, so.
Your Honor, I believe it's set to expire in February of 2023.
Right, so she thought, and she had him living back with him, but that thing, you need to deal with it. You need to go down to the courthouse and do whatever it is that you think needs to be done with it, because it's still sitting out there. So now he's got a violation of injunction charge on that. And I didn't look up the 2 trespass charges he's out on bond for. He's got 2019 MM 9838 and 2019 MM 7984, but we're going to appoint the public defender. And I ask you, what's going on? I think you was trying to get him Baker Act and he got arrested.
Actually, this time I wanted him arrested because he slapped me on the face, open hand, and on my shoulder. I can tell he held back, but he was very aggressive, threatening, talking. And he's like 6'4", 240. So I said the next time it might be worse. I might not be able to.
Right. And you thought that he had been, gotten his shot at Aspire, but you think maybe that didn't happen because it wasn't working?
No, they didn't administer that. Under no circumstances. They didn't do that. I don't know what they did. They called and told me that they were going to give him the Vega shot. But I know from his behavior
that it didn't happen. So what do you want us to do? Because, I mean, I know you got wanted him arrested to keep him safe, but if he's not competent to stand trial, have you ever been through that process where, he goes through that whole determination of whether he's not guilty by reason of insanity? It takes a while. If he's in jail, first there's one expert who comes in, interviews him, then there's another one. And unless the judge and/or public defender rides that case and makes those expert appointments real quickly, he could sit very easily for 90 to 100 days in jail, just waiting the reports of the experts, the way it goes.
Well, really, he needed mental health.
Right.
He needs help.
So what we do here is we start this, is he competent to stand trial? And he's got to have the expert reports, and the experts get around to it, but it doesn't happen immediately because of the way it's structured, unless somebody's figured out a better way to get them all appointed at one time.
Is he eligible
Probably hasn't happened yet. So, I just want to warn you, if you're trying to be safe, you could end up having to ask the public defender at some point to have a hearing, to let him out, because they got him on the 5th floor, and he may or may not have medication, and it's not the best place.
So is he eligible for mental health pretrial release?
My guess is because of violent history, probably not, but we'll ask.
And you can just have him screened, Your Honor, but we will never know when they tell us. We don't know unless you have him screened.
But she doesn't know. Yeah, well, we could ask. But the best thing would be, if the lawyers continue to check in with you, and that is depends. You might get, okay, so it's going to be in the domestic division, so there might be some people who've been in there for a little while, and the judge probably is going to be very attentive to the situation, Judge Shoemaker. But you really one like this really needs case management, because if they just sit there and wait for the evaluations, it could literally be 90 days.
Okay, whatever you think is best.
Well, no, I mean, I'm just telling you, I'm not going to make any decision for you, but I'm just telling you, I don't know what to tell you, because you've got a situation. You got a 6'4" son who weighs 240 pounds, and if he's off his meds, it's a problem.
Yes, it's been going on since he was 22.
22?
Yes.
God bless you. I don't know what to tell you. All I can tell you is that the criminal justice system is not optimal.
Okay.
All right? I wish it was. Now, you could try mental health pretrial release and see if they can help. I don't know if he's going to qualify or not, because he's got a couple of pending trespass cases, and, He's had carrying concealed weapon, battery, assault stuff, and he might not qualify. I don't
Okay,
know.
what is the case management? What was?
Well, case management is not something completely institutionalized. It's not like a system. It's, to me, it's what a judge is going to do to make sure that nobody falls through the cracks. And you're going to have Judge Shoemaker, I believe, in domestic, and I think he probably will be diligent in regard to that.
Okay,
But I don't know about the lawyers, because the lawyers come and they go. It's a lot of, they don't stay with the public defender's office very long because they get a better job and they have to pay student loans. And so you get, you might get 3 different lawyers while the case is going on, and they may or may not know about mental health. And so I can't tell you that the system is efficient or extremely responsive. But what I can tell you is that's what you need in this case, because otherwise he could sit for a while.
Okay.
Because it takes a while to get those reports. I know I've said it 3 times, but that's just the truth. I'm just telling you the truth about that. So whatever I do, I'll give you an alternative bond amount so that you can make a decision at some point. If he's been in there too long, it's taken too long, and you want to get him out and try to deal with it the best way you can, because you're not feeling like you're getting any help over here, that you'll be able to bond him out.
okay.
Okay? And then the other question is, do you want to have contact or not? Because the state needs to ask you questions about, can you feel safe? And you may not even know yet, but we'll do the best with what we got right now.
Contact, other than in my home, I just don't feel comfortable with them being confined with me in the home.
Your Honor,
Okay,
may I inquire? I don't think we even got her name on the record.
sure.
Ma'am, can you please state your name?
Terry Turner,
And Mr. Wright is your son?
yes,
Okay. And you stated you wanted to have contact, just not within your home?
no.
Okay. And things like this have happened before, correct?
In 2018, that was it.
Okay. And are you afraid of him?
In that state without his medication. We have lived together. When he was medicated, it was fine, but when he's not on his meds, it's like I'm his enemy.
Yes, ma'am. Thank you. Your Honor, state would request mental health PTR and then in the alternative bonds, and as conditions, they would ask for no hostile contact, but a no return to the victim's residence, and to comply with all psychiatric drugs and prescriptions.
All right, now, about these trespass cases also, I understand what she's asking for, ma'am, and I'll go along with that. I
just
think it's
request that you-
consistent with what you want.
State requests that you take no action, Your Honor. They're both in comp hearings.
They're in mental health hearings?
Yeah, they are.
Oh, okay.
There have been multiple comp hearings on both of them.
All right. Okay, then, no action on case number 2019 MM 9838 and 2019 MM 7984. Now, ma'am, he wasn't able, I think, to fill out a public defender form, but you think we should appoint the public defender for him, so he's got a lawyer?
Yes.
Okay, so let's appoint the public defender. In regard to the new cases, I'm going to set you a bond amount as an alternative in case he doesn't qualify for mental health pretrial release, okay?
Okay.
So we'll authorize mental health pretrial release. I'm not sure they'll let him because he's just got a few too many cases in his background at this point. And so the alternative, I'm going to make it lower for your sake, because you'd be the one making the decision to get him out, I think. The violation of injunction, I'm not going to worry too much because you thought it was dropped, but you do need to go back and.
Because when I went to court.
I know, but go back and tell the clerk you need to file something and file it and ask it to be dismissed if that's what you want.
Okay.
Because it's still sitting out there on the battery. I'm going to call it, does he have any way to get out without you?
Nope.
No, okay, so we'll just call
a
it,
bondsman.
he
could call a bondsman. He's
he
30 years
could,
old.
but he doesn't have any money, does he?
He has money, but I can't get it. Cause
Right, but what I'm worried about is I want to put you in control of getting him out, in which case I'm going to give it a low bond. But if he could get out on his own and be crazy out there, I want to be careful about that.
Yeah.
Your Honor, the state would just ask that you set the normal bonds.
Like $1,000 on the battery and ROR on
100.
the injunction, because that's not going to stick, I don't think. And the requirements as an alternative to the bond, mental health pretrial release if eligible. No hostile contact, which means that you can kind of control that situation, but no return to the mother's residence, a police escort to get some things out of the residence if he needs it, comply with all prescribed medications and treatment while out on bond. No guns or weapons, those have to be put in the custody of the law enforcement agency within 24 hours of his release. And hopefully we can help you, man, but I know his situation is a little complex.
Yes.
Good luck to you.
Thank you.
You're welcome.
Are we gonna call back up Mr. Sagastume?
Are you talking about the recall?
It was the one that was reading a Spanish plea form?
Right,
I just don't want him to get bogged down
yeah,
in the line.
no problem. Yeah, he's been there for a little while. Okay. All right, let's go ahead and call again.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has already been sworn, Your Honor.
Thank you so much. We have Mr. Sagastumai. The case number is 2021MM343180. It's a violation of county ordinance. We were attempting to finish a plea to time served, but he hadn't read the plea form, so now he's had a long time to read the plea form because we did a lot of other cases first.
Your Honor, could Your Honor repeat the defendant's last name one more time? Sorry.
Yes, it is spelled Sagastume.
Thank you, Your Honor.
And I tend to pronounce things in German, so it probably was strange.
Sagastume.
Silas Gume. Oh,
No, Sagastume.
Stume.
very unusual. Thank you.
Yes. Yeah, it's kind of like half German at the end. So, sir,
No,
no, it's okay. So, did you read the plea form?
sí, señor.
And
Yes, ma'am.
he was previously sworn in. So, sir, did you wish to resolve the case with a conviction for violation of county ordinance and credit for time served? I heard.
Sorry, Your Honor, the interpreter had a hard time hearing, that's all.
He said très bien.
Sí, yo no entiendo mucho del caso, pero quisiera saber si yo me pongo
Sir?
no contest.
Do us a favor and speak shortly because we have a lot of cases today and we have to go fast. I'm sorry, but we do need for you to go fast, okay? Did you read the plea form?
Sí, lo leí.
Yes, I read it.
Read it.
And you would be giving up all the rights on the plea form. Do you understand that?
Al firmar el papel, yes, sí.
Yes.
You won't have a trial, you won't have a defense, nobody will have to prove beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that you were actually violating the county ordinance.
Sí.
Yes.
And you won't have any real appeal rights. Nobody will make any technical objections to the state's evidence. It's just, you're giving up the rights in order to finish the plea or finish the case today. Is that okay?
Yes, sí.
Yes.
Okay, sir, any criminal charge can and very well might result in deportation if you're not an American citizen. Do you understand that?
Ciudadano.
I'm a U.S. citizen.
Okay. And if you were on probation for anything, this would violate probation. Do you understand that?
Sí.
Yes.
All right. It appears that you are alert, intelligent, not under the influence of anything, that you understand what is going on, that you are entering a plea in a free and voluntary manner. There's a factual basis. We'll accept a plea, find adjudicate you guilty on the charge of violating county ordinance, sentence you to the 2 days time served, thank you. Release you to this charge, as to this charge. Now, we impose court costs and give you a year to pay. Good luck to you, sir. And thank you, sir.
Thank you.
Okay, thank you to the interpreter. That's all we had, I think.
Quite welcome, Your Honor.
Thank you. Okay. Is this Mr. Al-Hulawa?
Yes, Your Honor.
Thank you very much, sir. Oh, I forgot to give you this. Thanks. Sir, okay. If that's your weekly income, you might not qualify for the public defender, although they might have talked to you about it. This is a Spanish plea form. Do you need an interpreter?
No, Your Honor.
Okay.
No, I think that was Sagastuma.
Oh, that's the one we just did. I'm sorry. Sorry. Sometimes I just get tired when we have a lot of cases. This is 2021 CT 1264AO, Division 63. It's an alleged failure to appear with a bond amount of $500 on a driving without a license charge.
Your Honor, state committed an offer of an adjudication credit time served.
Okay, and I don't have your criminal history or your driving record in front of me, sir. Adjudications are significant. Looks like you don't have any adjudications yet, although you've got some arrest history. But criminal convictions are things that you report on job applications. I see here some arrested for non-immigrant overstay, whatever that is.
He has some out-of-state convictions, Your Honor.
Out-of-state convictions. Oh, I see.
And Your Honor, he doesn't have a driving history. As I was looking it up earlier, it stated that he doesn't have a David.
All right, so his place of birth is a different country. So, sir, you need to be careful about getting criminal convictions. They are dangerous in terms of deportation requirements, and that's a total crapshoot right now. If you're not an American citizen, you can't get a license.
Your Honor.
I can tell you.
Talk to the public defender if you have a question about that. I'm just trying to figure out if I need to. Yeah, he's already got convictions. Okay, I see.
Your Honor, I don't think he was interviewed for PTR. Would he otherwise qualify?
Yeah, he's got some convictions.
It's just if we request a bond, I don't know if he'd be able to bond out on his own. He's informed me he doesn't.
Oh, the bond is
It's a
$500.
failure to appear. I would ask that you
So it's not,
keep
you
it at
know,
that amount.
it's not a whole lot. If you have trouble figuring out your court dates, it's online, it's public record. under the clerk's website. Is he concerned about immigration consequences or conviction? He's got,
No, I think he was transient, a homelessness issue, didn't have any access to check his court dates, the reasoning there. I think the other issue is the bond, the monetary bond is going to keep him here.
$500 bond is going to keep him here?
He says he doesn't have anybody to bond him out.
Okay, no family members here. Yeah, and he's got, the last conviction was December, evading arrest, detention, assault, causes bodily harm and family member, but is out of state. So, if he's got a family member, they might be a little bit aggravated, too aggravated. So, sir, you need to, you can only run for so long. I can't really help you here. I can't just let you back out. You've got to get control of your situation. Somehow. And I don't have a better option for you. I think, maybe try to initiate contact with the family if you want to get bonded out. But then you're going to have to maintain your situation so you can actually make court dates. That's a relatively basic, primitive expectation of adulthood. So either bond out or I can offer you a time served plea, but you're starting to mess up your criminal history with convictions. And this says that you make $600 a week. Now,
He does have a friend, his boss, if he could access his number, but he's saying the number for the boss is in his phone. He doesn't have access to his phone right now.
Your Honor, say what just asked that you set a bond, so we can.
it's $500, sir. Now, you'll figure it out. If you are working and you're intelligent, you'll figure out how to get out of jail. It's not my position here to make it, turn everybody out. So, figure it out.
And you appointed the PD?
Well, supposedly make $600 a week, do you?
Yes, Your Honor.
All right, so I don't know why you're homeless, but,
I only spoke as a friend of the court, Your Honor.
oh,
Spoke with him.
all right, well,
Your Honor, I was, but I just got my job like 3 days ago.
I can appoint the public defender for now if that's what you want. And bond is $500. Good luck, sir. I have to move on.
Take a step out.
21 CT 3682, Division 63. Sir, the allegation is reckless and, no, he bonded, right? Batista Valentin bonded?
Yes, bonded, Your
Okay,
Honor.
I'm sorry. It's tabulated and I didn't even look. Is this Mr. Abdel Bosque?
He bonded also.
He bonded, okay. And then I think the next person did also, which would be Fitzpatrick Palia.
Yes, bonded.
Okay. All right, so would this be Trenton Reed? Okay. All right, sir. This is case number 2021 CT 484 AW. You got arrested on a failure to appear warrant, and those are usually a $2,000 bond. We can appoint the public defender in case they were not already appointed.
Your Honor, an offer was conveyed of a withhold and credit time served.
Okay.
And Your Honor, I did speak with Mr. Reed in the back. He would just like a reasonable bond. He's not going to accept the state's offer.
Okay, well, 2,000 is the typical for failure to appear, sir. So you need to call your family member and try to, get them to bond you out. You're only 19. But don't take this stuff for granted. You're gonna, if you need to get second job to dig yourself out of the hole, get your license straight, do it, because you can get yourself in a hole really fast with these driving while license suspended cases. And if you have trouble figuring out when you're supposed to come to court, just look it up on the clerk's website, Orange County Clerk of Court. It is public record. You're now allowed to look at it and figure out what your court date is, okay? Good luck. No problem. Is this Mr. Watkins? Okay, sir. We have, let's see, a complicating situation with you being on maybe state probation. So I probably got paperwork in regard to that here. And the new cases are case number 21 CT 494 AE and 495 AE. An alleged no valid license and driving with license suspended. They have enough information to file those. Oh, let's see here.
So is his license suspended, or does he not have a driver's license?
Did you ask a question?
Yes, Your Honor, I see two charges, one license suspended, one no driver's license. So I'm unaware if he has a driver's license that's suspended or he has no driver's license.
Well, so the police officers tend to give him as many charges as they can.
Mhm.
Now, that doesn't mean he can be convicted of both at the same time. And I don't tend to worry about it too much at this point. I'm just trying to figure out if, let's see. They did something else because they ended up is suspended for failing to pay a couple of court obligations and also fleeing and attempting to elude and controlled substances
I believe
back
it's
in
an
20
893
2019. He has what?
It's an 893 suspension currently, Your Honor.
Right, he's on probation for the fleeing and attempting to elude and not allowed to drive as one of the conditions of his probation. So that's, but they also arrested him for resisting without violence, violating probation. Okay. All right, so, Mr. Watkins, in regard to the violation of probation, is that a Seminole County? I'm not exactly sure what the case number is. I'm going to have to no bond you on that because they're going to do it anyway, but Seminole will come and get you pretty soon.
I believe it's 19 CF 1445.
Okay, thank you. You want the public defender, did you fill out a, okay, yes, here's the form, I'm sorry. I can appoint the public defender on your local charges, and then they'll appoint the public defender over in Seminole County on the VOP, and you and your lawyers will figure out which ones you want to handle first. But the ones here, the driving with license suspended, and no valid, they've got it at 500 and 100, that's fairly normal. We'll stay that in case numbers 21 CT 494 and 495 AE. In regard to the resisting, that is 2002-1 MM 98 AE. And sir, I'm just going to add that as a $100 bond instead of it as if it's a separate whole case because it's the same transaction. I'm not trying to hurt you as far as the level of conduct that was all together, and you're already hurting on the violation of probation. So just set the bonds on the other ones for you. And good luck on the VOP.
Yes, ma'am.
All right, we got some misdemeanors.
Are we going through misdemeanor pleables, or do you want to do the RORs?
Well, they have me with the pleables first.
Okay.
I just kind of go with the flow, if that's all right.
That's perfect, Your Honor. Just make sure we're on the
Okay.
same page.
I figure they got everybody lined up in there. We got a few. Okay. Okay, I think the first case might be an Edith Basson. Thank you. 2021 MM 3399. And we can appoint the public defender if you want, ma'am. The allegation is trespass. It's going to Division 61.
Your Honor, there was an offer conveyed of an adjudication, credit time served, and no return to the Orlando International Airport without a valid ticket.
Okay.
May I inquire to the state, with the no return to the international airport, can that be without a valid ticket?
That's what I just,
That's what she put.
that's what I announced to the court.
Okay, thank you. Your Honor, I spoke to Ms. Basin about the state's offer. I informed her of the rights that would be waived as a result of entering a plea. I also spoke of the citizenship and probationary issues that can happen as a result of entering a plea. And I
Tell you
believe
what, we can do those twice or we can do them once. Which way do you want to do them? Because we've got about a bunch more.
you can do it if you'd like, Your Honor.
All right. I'm just worried about time.
No problem. I'm
Sorry.
Your Honor.
I know, I appreciate the knowing that you've talked to him about it because it makes it a lot quicker. All right. Ma'am? Oh, you sign him right now? Okay. Can you see me?
Yes.
Okay. If you accept the plea offer, you would be giving up the rights. Wait a minute, we better get you sworn in. Do you swear to tell the truth?
Yes.
The whole truth and nothing but the truth?
Yes.
Okay. And I'm sorry I'm talking fast. We just have a lot of cases today. Did you have a chance to read a plea form?
Yes, ma'am.
Okay. Do you understand the rights on the plea form?
Yes.
And that you would be giving up all those rights if you plead no contest? That you won't have a trial? Nobody will have to prove it?
Oh, yes.
Do you
No
need a minute to look at that form again?
Yeah, I saw it.
Okay. So you won't have a trial. Nobody will have to prove beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that it was proven that you were on that property when they were telling you not to be, and that you kept staying there. And they would have to prove it beyond a reasonable doubt, and you won't have any appeal rights. The whole thing will be over without them having to prove it or hear any defenses on your behalf. Do you understand that?
Yes.
Okay. And you already talked to the lawyer, but if you're not an American citizen, any criminal charge can cause deportation, and if you were on probation, this would violate your probation. You understand those things?
Yes.
Are you doing this of your own free will?
I have a public defender.
Right, you do. I mean, he's over there next to you.
Yeah.
Okay. Are you doing this of your own free will?
Yes.
Okay. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There were sufficient allegations in the police report to accept a factual basis, so we'll accept your plea of no contest. Find, adjudicate you guilty of trespass after warning, sentence you to I think 2 days, you've already got time served.
Yes, Your Honor.
Release you as to this charge. Order that you not return to Orlando International Airport without a valid ticket. The court costs are imposed, ma'am, they're around 300 something, but we give you a year to work on it and you can make partial payments. Thank you very much, ma'am. I'm sorry to go fast. We just have a few too many cases today. Thank you very much. All right, yes, sir. Is this Mr. Bellamy?
Oh, yes, ma'am.
Thank you very much, sir. This is case number 21MM3421, Division 62. We can appoint the public defender if you need it. I'm sorry I'm talking fast, but we have a lot of cases today. The allegation is trespass. And we'll also deal with you being out on bond for a possession of cannabis resisting, possession of cocaine case.
There is no offer at this time, so state just ask that you stay the bond.
Your Honor, I spoke with Mr. Bellamy. He would like to plead to the court. I believe he wants to request credit time served for the trespass. And I would speak.
Your Honor, there's a victim in this case, and they have a right to be heard under Mercy's law.
Is that why
Yes, Your
you're not
Honor.
making an offer? Okay, so there's a property manager.
I looked up the residence in
Ma'am?
question. I looked at the residence in question, and it is a standalone house.
And it's a house?
Yes, Your Honor. It's not a business, which is the ones that I usually plea out.
Right, okay. 3 individuals on the porch. Authorized contractors, okay. So this is it may or may not be inhabited, but people are on the porch. And there's an active trespass authorization, so the officers are allowed to arrest people for trespass. Okay, so all 3 were arrested for trespass. Okay. Revere, Bellamy, and Johnson. Okay. Well, he's out on bond. So the request is plea to the court because the state normally is going to request victim input. This is a property manager who probably doesn't want to have to deal with this sort of thing. Let's see, he's got a bit of a history. 8 felonies, 11 misdemeanors, 6 fails to appear, 23 unknown, 4 Department of Corrections. So yeah, I guess he wants time served. He's been very active. Possession of cocaine. And the ROR, was that because of a 33-day motion? I did not look that up.
One is out on bond?
Yeah, it was possession of cannabis, cocaine resisting. The arrest was 4/18/2021. Oh, the bonding was 5/4, so that was not an ROR. That he actually got bonded on that.
It was a 33-day motion, Your Honor.
21 CF 3552 was an ROR motion.
It was?
Yes, Your Honor, on 5/3, and then he picked up this case in the meantime.
All right, did the state ever file?
Not yet, Your Honor.
Oh, okay. So I'm not going to revoke his bond. I'm going to take no action on that. All right, well. How many trespasses have you got? So basically what we have is a young man, pretty much, 34, that, to me, that's young. Who is.
Your Honor.
No, you know, whatever it is you're telling me, I've heard it before. I'm just looking at your prior history, to be honest with you.
Yes, ma'am. I just want to say one thing to you.
Time for, that it was just, yeah.
Your Honor, I believe the residence is used as a business for Narcan America.
Would you speak over the printer? Sorry.
I believe the The residence is used as a business for Narcan America,
Narcan,
which is,
like methadone or something?
I think that's the listed victim that the law officer wrote.
Well, okay, so, some people getting methadone hang out. That's.
At
what
11
happens at
a.m.
those
or
places.
11 p.m., Your Honor.
But they don't want him to hang out. I'm just looking at him. He's not doing anything with his life. He's doing a bunch of drugs and stuff.
Well,
So,
Mis-
I'm
Mr.
not going to offer
Bellamy-
you time served.
Say something. Hey, can I say something, Your Honor?
Yep.
Your Honor, listen. That residence was a house. It was a regular house. I just walked on the porch. As soon as I walked on the porch, Your Honor, I got the police pulled me. The police pulled up and they.
Well, hold on. The reason I'm not listening, I usually would listen. I got a million cases today, number
Yes, ma'am.
one. Number two, having been sworn in to practice law in 1980, having been a public defender, having been a judge for about another million years, do you know how many times I've heard that? Sir, you're not doing anything with your life.
Yes, ma'am. I
Not
got
doing anything with your life.
I got a
If you
job right
want-
now.
No, you know what? It's 10 days if you want to plead or bond out.
I'll take the 10 days.
All right. I don't have time for excuses when we got this many cases and you've got a record. That's all.
All right. I'll take the 10 days.
All right. Did you want to read or sign a plea form then? And raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay.
Attorney.
All right, they're getting you the plea form, but you've seen it before, correct?
Don't do that when I get you out of here. All right.
Can I talk to him? You guys are doing something, I don't know what it is. Okay. All right, I'm not going to hit you with anything on that one. You're out on ROR 4. They didn't drop it, they just never filed it yet. I don't know when they're going to file it. And if they do, you need to show up to court. But this one, you understand you give up the right to have a trial or defense, and if you were on probation, it would violate your probation. With a nodding of a head, you're saying yes.
Yes, ma'am.
Any questions?
No, ma'am.
All right. Now, sir, I'm sorry, but it's just your record, and to me, it's 10 days because you need to start getting right with your life instead of messing with stuff and going places that they don't want you.
Yes, ma'am.
But I'll go ahead and find that you're doing this of your own free will because you know that 10 days is better than waiting for arraignment. And find it, factual basis, find adjudicate you guilty of the, I think they're calling it trespass. 10 days with credit for 2, and don't go back there.
So I got 8 days altogether?
Yeah,
Okay.
give or take. And the court costs are due in a year. And you might want to start just, getting straight so you don't have to deal with it 10 days or so every time you come back. Good luck.
Yes, ma'am. Thank you.
You're welcome. All right. The next one is case number 21 MM 3429. Is this Mr. Delaney? Okay. Right, sir, right here. The allegation is petty theft, sir, and we can appoint the public defender to represent you if you need be. The case is going to Division 81. Is this one that the parties are trying to resolve or not?
No, Your Honor, I believe it's enhanceable.
Okay.
Your Honor, we would just request a low bond if possible because
Yeah, shorts,
Delaney is-
T-shirts, socks,
he is got.
grooming trimmer,
Yes.
brush. All right, sir. You've been here for a month because your dad's in rehab and you're his caregiver. Okay. All right, transient and unemployed. Okay, sir.
Came in at 250, Your Honor. State we just asked you to stay it. Yeah,
it's 250. you got a bit of a history, so we could just leave it at that. Try to get somebody to bond you out so you can help your dad. But we do arrest for things like that here.
Your Honor, state would ask for no return to the Walmart.
All right, so ordered. Don't return to that Walmart. No, they don't want to plead it out because they want to see if they can enhance it. So when you get out, you'll have some court date to come back to. All right. Is this Mr. Fillmore?
Yes, ma'am.
Okay. This is case number 2021MM3428. While out on bond, in regard to another petty theft case, we'll appoint the public defender on the new charge. And the new charge is petty theft also, going to Division 81. Thinking the state's not going to want to plead it out if they are concerned about trying to.
No, Your Honors, there's no offer at this time. I believe it's enhanceable. He just pled to a petty theft this month at IA.
Oh, okay.
And has an open petty theft also.
All right, he pled to one and he's out on bond on one?
And I believe he has another one as well.
Okay. It's starting to get complicated, Mr. Fillmore. Let's appoint the public defender, find probable cause, even though it's, a Slurpee and things like that.
Your Honor, we would have you make no action on the out on bond case. This current charge is over a matter of $8.
Your Honor, state would ask that you revoke and set a new bond. The condition of being out on bond is not to commit any new law offenses.
Did he post a bond? It says NA.
It was ROR.
Oh, was it a 33-day motion ROR?
No, he only, for 2 days.
Oh, okay. So I see what's happening here. He's getting these little ones for getting Slurpees and stuff, but he keeps getting them, and that's a problem. He doesn't have any, he hasn't figured out any other way to eat. So, sir, let's slow down the cases for a moment. Stay the bond at 500 on the current charge, find a probable cause, appointing the public defender, and 100 on the trespass. Let's revoke the ROR and just put that down as a $250 bond. I'm not trying to hold you indefinitely, but I'm trying to slow you down before you get yourself worked into prison, because these cases can be used to upgrade you to a felony case. So you need to slow down for a minute, talk to your lawyer, and, see if, it's not like they're going to get you a social worker or anything, but at least resolve these cases before you get more.
Your Honor, state would request a no return to the mobile in the incident case.
Okay, don't go back to any of the places where you got charges pending, sir. Good luck.
Yes, ma'am.
Mr. Hardy? Okay, sir. This case,
Morning.
good morning. It's 21MM 3440, Division 80. I don't have a public defender form, but we can appoint one. Oh, here, he's qualified for the public defender. It's a paraphernalia charge.
Your Honor, state's going to file a no bill.
No bill?
Yes, Your Honor.
Okay.
I just filed it with the court.
All right, thanks. So this state is going to drop its charge, sir. And I guess we're taking no action on the one that he's out on bond for?
Yes, Your Honor.
Okay, that's 21 CF 1087AO. No action. Sir, it's your lucky day. This particular one is getting dropped. Good luck.
Thank you.
You can thank her. Thank you. Okay, you think?
You will.
What happened?
I'm sure he meant that colloquially, Your Honor.
You just get a little bit of a gallows humor in here, because you see so much stuff. 2002-1, and in some cases, that's really true. I mean, there's guys that you see every week. Is this Miss Ayana Johnson? 21 MM 3422, is this another person on the porch?
Yes,
You
Your
don't have
Honor.
to say anything, ma'am. Yeah, just on the porch, okay. Oh, let's appoint the public defender. I understand the state wanted to talk to the property manager.
This is the same situation that
Yeah,
another individual
I'm
we
just-
had. I informed her of what happened previously with the plea to the court.
Well, what I'm doing is I'm looking at the prior records to figure out, because I respect the state's request to talk to the property manager, but I also think sometimes it takes longer to do that sort of thing, and they sit for, 15, 30 days before they come back on arraignment.
And from my perspective, Your Honor, just in the interest of equity, if one person can get a plea to the court, I would say the other.
No, well, yeah, I'll be consistent.
Thank you, Your
The
Honor.
only difference is going to be looking at the record and trying to make the best guess, and not that I don't think that the property manager should be consulted, but a lot of times I'm just trying to do what I think they would think would be okay anyway. The main point being to stay away because they don't want anybody hanging out on the porch.
I understand, Your Honor.
And I'm a little worried about her too. I mean, you know, I'm just worried about people with criminal history roaming around and doing stuff. So I'd make you the same plea offer, ma'am. I just want people to straighten up, that's all. Okay? So I offered the other guy 10 days. I'm just basically reacting to the background and history, that's all. And you could take it, or, I don't have a problem setting up a low bond if you got a family member that you could contact. I can't hear anything, ma'am. You'd take the 10 days? Okay.
Yes, ma'am.
All right, go ahead and look at the plea form and see if you recognize it.
Hold on. Just gonna-
All right, ma'am. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. You can put your hand down. And I need you to speak up just a little bit because I have trouble hearing over the printer, to be honest. So if you've seen the plea form before, do you understand that you're giving up those legal rights to have a trial or a defense?
Yes, ma'am.
Nobody will have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved it. Do you understand that?
Yes.
Nobody will hear any technical objections to the state's evidence. There's nothing left to appeal. Any questions about the rights?
No.
And are you doing this of your own free will?
Yes.
Okay. If you were on probation for anything, this would violate your probation. If you're not an American citizen, this very well could result in deportation. Do you understand that?
Yes.
All right. Ma'am, I think that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner, and as a practical matter, it might be easier for you to resolve it this way than to try to bond out, but also, even come back to court and deal with it. So we'll go ahead and accept your plea of no contest as being freely and voluntarily entered, find adjudicate you guilty of trespass, tell you not to go back to that particular place. Give you 10 days with credit for 2. We do impose a court cost of around $300 or something, and we give you a year to work on it. They do take partial payments if you're trying to keep it from being a suspension on your license, which is what we do in Florida. We suspend people's license if they don't pay their court costs. All right, good luck to you.
Your Honor, is there a no return to the?
Yes, I did say that. All right, thank you, ma'am. And this is a Deshaun Jones, case number 2021MM3430. Sir, we can appoint the public defender to represent you if you want. It's going to Division 80. It's a trespass case. Currently, the bond is $500.
State did convey an offer, Your Honor, of an adjudication credit time served and no return to the Lynx bus station at 455 North Garland Avenue.
Okay. Sir, did you want to take the time served, or did you want to bond out?
Oh, no. I'll take the time served, I mean.
All right, make sure when you look at that plea form that you remember it or read it.
Okay.
Okay, if you want to sign it, they're giving you a pen, I think.
Your Honor, I did have a chance to speak with Mr. Jones in the back as well.
Thank you. All right. Sir, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You may put your hand down. Sir, you'd be giving up all the rights listed on your plea form. Do you understand that?
Yes.
You won't have a trial, you won't have a defense, nobody will have to prove it beyond a reasonable doubt to a jury of 6 people.
Yes.
And you won't have any appeal rights or anything. It'll just be over with, and it'll be on your record as a conviction. Understood? If you were on probation, this would violate your probation, and if you are not an American citizen, you would get deported. Do you understand that?
Yes.
Okay. I find that you're alert, intelligent, and a plea of no contest in a free and voluntary manner. There's a factual basis to accept your plea. We'll accept your plea. Find adjudicate you guilty, sentence you the 2 days you've already served. Don't return to the Lynx bus station. They probably have a trespass warning out. We do impose a court cost of around $300, but we give you a year to try to work on it if you want to make partial payments. And I'm sorry I'm going fast. We just have too many cases today. So I'm sounding really fast. But that's all we got.
Okay.
Good luck. So next person coming in, I think, is Tyrell Levy, case number 2021MM3432. And he might be out on bond in regard to 2021 CF 3645, possession of methamphetamine, etc. So, Mr. Levy? If you need the public defender, we can appoint their office to represent you. And the new charge, oh, wait, does he have more than that? He's got,
Yes, Your Honor. He has 2 cases and an out.
oh, he's got a Seminole County?
Yes, Your Honor.
All right.
I spoke with Mr. Libby in the back. If there's no action on the out-on-bond case and he can accept the state's offer on the resisting officer without violence, then he can hopefully be taken to Seminole to deal with the out-of-county warrant.
Okay, got it. All right, then. So what was the plea offer on the resisting? I'm sorry, I didn't hear that.
An adjudication, Your Honor. Credit time served.
Okay. All right. Okay. All right, so the Seminole County is a failure to appear on a driving while license is suspended, and some of these failures to appear, they just put them at no bond, sir, so they'll go pick you up and you'll deal with it. In regard to the resisting, it looks like you already have some other stuff on your record, so you probably don't mind one more. But you would, I better get you sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can put your hand down. Do me a favor and speak up. I'm having trouble hearing.
Okay.
You'll be giving up all the rights on your plea form. You won't have a little trial where, you know, your lawyers fight over whether or not you heard the officer, or whether you should have stopped or not. And then the officer gets to try to convince the jury that you should have stopped, and you won't have a trial over that. Do you understand that?
Yes, I understand.
And that you understand that your lawyer would question the witnesses, and the jury would be told they have to have proof beyond a reasonable doubt, and they have to all be unanimous before they can find you guilty. Do you understand that?
Yes, I understand.
Is it easier to just get time served and get it over with?
Yes, ma'am.
All right. If you were on probation, you'd be violated on your probation, and if you're not an American citizen, you might likely be deported. Any questions about that?
No, ma'am.
Okay. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis, at least from the way the police officer looks at it, and a jury could maybe find that. We'll find and adjudicate you guilty of resisting an officer, sentence you to 2 days of time served, release you as to this charge. We always impose the court costs, and we give you a year to pay in case you want to try to make partial payments on that. And taking no action on the other one that you're out on bond for, but be careful, once you're over in Seminole County, that you keep track of your court dates on the felony, because you know if you don't come back on time, they'll bond you on that.
Yeah, I know you can't do nothing about that.
No, I can't do nothing about
I
that.
really
You have-
had a question because I was told by clerk of courts that that case was dismissed.
So, do you have access to the internet?
Yeah, Orange County Clerk of Courts.
Right, you just look up Orange County Clerk of Courts, and you can see the last paperwork that's been filed. So, a lot of times people think things are dismissed, but you need to keep track of it on the website. And also your lawyer, hopefully you can get a phone call into your lawyer on that.
Yeah.
Okay, we have a John McKenzie, case number 2021MM3441, who will be next. Littering and resisting, Division 84. Oh, did I forget to sign that? All right, is this Mr. McKenzie?
Yes, ma'am.
Okay, sir. I didn't know if you want to fill out a public defender form, but that's always an option
Okay.
for you.
I'm all right.
You're all right. Okay. It's a misdemeanor, so let's see how far we get with this.
Your Honor, as a friend of the court, I did speak to Mr. McKenzie about the state's offer.
Oh, okay, thank you. So he's probably wanting to resolve it?
Well,
Yes, if I could.
Okay,
Your Honor, the offer conveyed was an adjudication credit time served.
all right. All right, sir, if you want to resolve it, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Oh, okay, this is about the alleged tensing and putting into cuffs after they were trying to get you for a littering infraction.
Well, Your Honor, he was waiting cooperatively for the ticket, and then he put his cigarette out in the gutter, and they got the littering ordinance violation.
Oh, okay.
And then there was a resisting arrest charge in their
Tensing.
in their attempt to arrest after the littering.
I can't hear half of what you say.
I'm sorry, Your Honor. It's just the facts suggest that he was cooperating for the writing of the ticket, and then put his cigarette out, and they cuffed him for littering. That they didn't-
Probably, maybe they didn't like his attitude or something, so it started to happen.
Yeah, no facts stipulate that the officers gave him a chance to toss the cigarette into the trash. It seems like they just arrested him for the cigarette.
So do you want to dispute the facts and not plea?
No.
No, they arrested him supposedly for tensing, but when you see stuff like this, you think maybe they didn't like his attitude, but he still wants to plead out because it's easier bonding out or something?
That's correct, ma'am.
All right, and you're here from New Jersey?
Yes, ma'am.
Okay. And you've got some prior stuff on your record, so you maybe don't care about one more, I guess.
Yeah,
Well, you don't have to.
All right. Okay, I mean, this is the kind of thing you could play with, but you don't want to come back from New Jersey because you're just on vacation, right?
No, I had come down to work.
Okay,
I was working over there in Orange.
okay. All right, well, if you want to get it over with, then, did I get you sworn in?
I did do the hand up and swear to tell the truth.
Okay, thanks. I've seen so many today, it's starting to all flow together, I'm sorry. Did you read the rights on your plea form?
I know them.
You know them, okay. So you'd be giving up the right to have a trial and play with it and see what a jury would do with it, and nobody will have to prove beyond a reasonable doubt that you were tensing up when you shouldn't have been.
Ma'am, I don't need to waste any more of the state's time or mine.
Okay, I got it. If you were on probation, you'd be violated. If you're not an American citizen, you'd be deported. Any questions about that?
No, ma'am.
All right. Sir, I find that you're alert, intelligent, entering a plea of no contest in a free and voluntary manner. From the officer's point of view, there could be a factual basis on this, so we'll accept your plea. If I adjudicate you guilty of resisting, sentence you to 2 days' time served.
He has 1 day, Your Honor.
One?
Yes.
Okay. And so we do impose court costs are about $300. We give you a year to pay in case you need some help with, making partial payments. And you can do that at the clerk's office, I think, online.
Okay.
All right, good luck to you.
All right, thank you.
You're welcome. Okay, we have a Mr. McCoy with 2002 1MM 3436. And we're supposed to call mental health before release, so that might be an issue. Mr. McCoy?
Sir, yes, ma'am.
Okay, no problem. I'll answer to either one. I've mixed up a couple genders in the past couple of days, but it's mainly because I'm blind, and then I get tired, when I see so many cases, so.
We can see each other. I see you.
Yeah, I know, I don't look like a man. It's okay. I've not been accused of that. All right, so the allegation is battery, so I'm probably not going to be able to plea you out because whenever it has a real legit alleged victim, we have to give the state more time to talk to them first. So let me look at it because I didn't get this far down in the stack, but we can appoint the public defender to represent you. Supposedly struck him in the right eye with his fist. And supposedly for no reason, according to the other guy. Okay, supposedly running his mouth. Oh, wow. Called him that name, you can have fun with this at trial. But they took him to the hospital? That must have been a heck of a punch. All right, well.
Allegedly, Your Honor.
No, but so, sir, he doesn't have much history. Well, he has some history out of state. I can say, counsel, I'm not gonna.
He wasn't interviewed for PTR. I don't
He
know if
was?
He was?
He was interviewed.
Was not qualified? Okay, thank you.
Your Honor, the state just asked that you stay the bond and order no contact with the victim.
Well, hopefully you're not living in the same area, but
Well,
don't, talk to your lawyer about it first. Supposedly when somebody calls you a name like that, that's almost like, batteries is supposed to be an unconsented to touching, but, if you call a person a name like that, you might actually expect something to happen. That's the problem, so I'm probably gonna cut the bond in half and make it $250, because I don't think he doesn't have much of a history.
Your Honor, he however does have a violent history.
Oh, he's got a little bit, he's not, for his age, could be worse than what we see every day. And they were probably when he was young anyway, I don't know. Okay, counsel, does he have to, do they live in the same area or something?
They have separate residences. I believe they might be next to each other different apartments, different houses. 3 apartments.
All right, can
So
you,
they're close, but I informed him about a one-time return with law enforcement. I think he only has to return once to get his stuff at his apartment. But the alleged victim does not live in the same apartment.
right, not the same, but next to each other?
Close, but I informed him of the no contact order, that there's no contact at all.
Is he anticipating, so is this within 500 feet or something?
I guess that's my concern, Your Honor, but that's why I perhaps suggest a one-time return with law enforcement to avoid any of that.
Well, then you're assuming that he has to move out.
Well, they don't live together.
I know they don't move, they'll live together, but the problem is, can we?
I'm not asking for a separate residence as they don't live together. I'm not asking for a one-time return because they don't live together, and I'm not asking for a distance requirement. I'm just asking
All right,
for
let's
no
just
contact.
do no contact then. Okay, I just want to make that clear. Okay, sir, can you stay away from him?
Oh, yeah, yes.
Okay, all right.
I say something, no?
You have the right to remain silent. All right, so look, I know he called you a name, but, you know, I'm going to make your bond $250 in relation to that. And you talk to your lawyer about it, make sure you come out all your court dates, just don't have any contact with him. I don't care if he's running his mouth or what, you know? Just keep the drama down while your case is going on, make all your court dates. If you have any guns, knives, or weapons, put those in the custody of the arresting agency within 24 hours because you're not allowed to have any guns, knives, or weapons while you're on bond for a battery, okay? All right, talk to your lawyer about it. Is this Mr. Natu?
Bonded, Your Honor.
Thank you. Oh, I see it right here, thank you. Is this Mr. Revere?
Yes, ma'am.
Let's see. Okay. I think you're the third guy on the porch, allegedly. The 21 3420. You can qualify for the public defender, and it's Division 84. The state didn't want to offer pleas on these because they're supposed to ask the victim what they want, and I offered 10 days to the other two because of background and history, concern about what the alleged victim probably just doesn't want people to come back, but I've been concerned a little bit about some of these criminal histories, and just wanting people to straighten up and not, you know.
Your Honor, I believe Mr. Revere's history is more significant than the other two defendants with his fact pattern.
Yeah, he's got some. Yep, he does 16 felonies, 22 misdemeanors. Yep,
That being said, Your Honor, he would plead to the court under the same conditions as the other two.
So about the only thing I can say about that is I might want to be consistent because otherwise I just want to be bend over backwards to be fair, and consistency is generally regarded as fair. Although, sir, you should understand you've got more of a history, and what I worry about is just, you know, just the safety of everybody, and also, you know, just this number of times the criminal justice system has to mess with this stuff. But, and the state's reasonably asked for more time, but I'll just give you the same plea offer because of consistency, and hopefully that's perceived as fairness. But you guys need to be careful about being in places where, you know, other people own the property and they don't want people there.
What is the plea offer, ma'am?
The plea offer is 10 days, only because it's consistent with the other ones. Because you got some history. All three of you have some history, but I think you're the oldest, so maybe your history's longer. But am I making you laugh, or are you doing something else, okay? I got a reputation for that. The court reporters used to love me. And the clerk who used to sit here when I was out here, we're Facebook friends, and she tells me, man, I wrote them down. She wrote them down. She had a legal pad, and she kept them. The stuff I used to say. That was Kim Houston. I had a court deputy in civil, and when I left, she said, Judge, I was parked outside your door because I want to hear everything she said. She said, and you tell it to them straight. Sometimes they really need it, Judge. Is this, are you telling, sir, we got to move on. I'm sorry.
We're,
Sir, just tell me, what is it?
he's worried that if he takes the plea, he's here for 8 more days.
Well, sir, we don't have to take a plea. You can bond out.
Oh, it ain't that. I'm just saying, more like maybe, you know.
Sir, I got a million cases today. You are 57 years old. The way you have conducted yourself in your life has put you in this situation. All right? You have been in the criminal justice system too many times. I don't have time for you to be whining. I don't want you to feel forced in any way, but I don't have to take your plea today. The state doesn't even want to make a plea offer. All right? I'm just going to stay the bond, appoint the public defender, wish you good luck.
No, I'm gonna take it.
Good luck, sir. Good luck.
That's a no return also, Your Honor.
Sure. It's not because I'm generally impatient, but I just need to make sure we keep moving on these cases today. We got too many. All right, is this Mr. Shapley?
Yes, ma'am.
Sir, okay, thank you, sir. This is case number 21MM592. A? Can't read it. 80, okay, 80. That's all we got on the Division to 83. It's alleged disorderly conduct. Sir, tell us, if you want a public defender, you're certainly allowed to fill out a public defender form, did I?
Your Honor, the state conveyed an offer of a withhold credit time served and court costs on behalf of the city.
Okay. Sir, it's a time served offer. Alternatively, it's a low bond of $250. Did you want to take time served, or did you want to bond out?
Just a moment, Your Honor. I believe he'll be accepting or entering a plea, Your Honor.
Okay, then. Sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you so much. Now, sir, do me a favor and speak up because of the mask and the printer over here. I can't hear, all right?
Yes, ma'am.
Okay, thanks. Now, sir, when you plead no contest to this charge, they call it disorderly. It's really panhandling, but they call it disorderly, okay? You'd be giving up the right to have a trial or a defense or to have the lawyers check through your case for any technical deficiencies in the state's evidence. They won't have to prove it to a jury beyond a reasonable doubt. Do you understand all that?
Yes, ma'am.
And are you willing to give up those rights in order to finish your case today?
Yes, ma'am.
If you were on probation, it would violate probation. If you're not an American citizen, you'd be deported. Any questions about that?
No, ma'am.
All right. Sir, I'm sorry, I'm going fast, but we need to today. So I'm going to find that you were alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis. We'll accept your plea. And I believe this was a withhold of adjudication.
Yes, Your Honor.
Okay, and time served of
2 days.
2 days.
Yes.
All right, and we're going to impose court costs, but give you a year to pay because you might need time to make partial payments.
Thank you, ma'am.
All right, good luck to you, sir. And we have a Mr. Solis, which is 2021 MM 3439, out on bond for driving with license suspended. All right, Mr. Solis, the new allegation is an alleged resisting charge, and you can qualify for the public defender. And we got the information about the driving while license suspended, so that's a little bit of a complicating factor, getting a new case when you're out on bond.
Your Honor, state conveyed an offer on his new case as well as his out on bond case. Both will be an adjudication, credit time served.
And I spoke as a friend of the court with Mr. Solis in the back that both would be resolved today if entering a plea.
He wants to enter a plea?
Well, no, I believe he, did you decide?
Here, let me read this, because
Yes, I believe he wants to enter a plea today.
but you need, I need to read the police officer's report on the resisting to make sure I understand what the deal, what the circumstances are. But these driving while license suspended, sir, it looks like you've already got a conviction for driving while license suspended in 2019. And I have not looked at your whole driver's record because I don't have that. I just have these little notes that jail staff prepares. If you get 3 driving while license suspendeds within 5 years, you get a 5-year driver's license revocation.
He has informed me he does have a valid driver's license at this time, but as you mentioned, Your Honor, if he does plead to the driving with license suspended, it is enhanceable.
My license.
So, and the other thing about the driving with license suspended case is that you probably are working with the judge on that to get some sort of better situation if you come back with a valid license. Am I correct?
I have an active license right now.
Well, sometimes you can get something that's not a driving while license suspended. You might get a better deal if you come back to court on that charge with a valid license. So let me see what this alleged resisting is and figure out if it's practical or not for you to resolve both. So, bike with no tag.
Your Honor, for your consideration, I spoke with Mr. Solis just now, and if there's no action on his out-of-bound case, so that he can do just that, take it in front of the judge and
Okay.
show his valid driver's
Okay,
license.
I'm just reading the resisting. I understand what you're saying.
Thank you, Your Honor.
Start up as an attempt to flee. Just dirt bike past him. Oh. Only pushed his arm away because he had to use the restroom? Well, sir, I'll go along with the time served on the resisting and let you back out on the driving while license suspended in the hopeful assumption that you're telling the truth about having got your license back, but you have to go back to that judge anyway. Do you want to take time served on the resisting?
Yes, ma'am.
Now, the resisting, if you ever try to flee from a cop, you could get yourself in more trouble, like fleeing and attempting to elude, even on a bicycle. So don't be playing with that kind of stuff in the future. I don't want anything I'm doing here to minimize the gravity of the situation on the resisting. Just do what they say, even if it's something petty and you think it's stupid, just say yes, sir, and no, sir. Don't even play with it, okay?
Right.
Half the time they're searching for drugs anyway, just deal with it. Just roll with it, okay? All right, so, I think they're asking for an adjudication on the resisting because you got some prior history. Any questions about that? You have to be careful about getting criminal convictions. Because they start adding up on your job applications.
My license points will go up, right?
No, not for a conviction on a resisting. But when you apply for, you want to lease an apartment, when you want to get a job, and they do a criminal background check, you're cluttering up your history. You understand that? So at some point, you might want to just start getting super straight about everything and playing by the rules, or it's going to start kicking you in the behind, even if you just try to get an apartment or something. Okay? All right. But I understand you might want to try to just get out today, and that's why you're doing it, unless you want to bond out, you'd rather,
I paid the bond already, it's been paid.
for this?
No, for the resisting.
You're pleading out to something you already bonded on? He might be confused. You bonded out on the driving while license suspended.
No, what he's saying is, he tried to post bond early this morning, about 1 o'clock. They accepted the bond, but they called the bondsman, as I'm reading, Central Florida bonding, because he had a fad, so they took it back off.
Right, because of the dwellers, they didn't let you
Yeah,
bond out.
they didn't pay the bond, they took it back off.
Okay.
So you might have to call them again.
Rebonded again?
You might have to call them back to bring the bond back, because they just took it. They took
Do you want to bond out, or do you want to plead out?
Yes, ma'am.
I think we're getting wires crossed, Your Honor.
No, I got it. He tried to bond out. They wouldn't let him because he was out on bond. That creates a first appearance detainer. He's got to see the judge first. And I'm considering letting him out. The only problem is, sir, this is deep stupidity that you're getting into here. I'm going to let you bond out. I could, and a lot of judges would just revoke you on the dwellers, all right? Or double the bond is normal. So that, yeah.
You're going to take back the plea?
No, well, I'm not going to, if he doesn't want to plea, I'm not going to plea him.
I think that's where we're getting our wires crossed. Because,
Does he want to plea or does he not?
okay.
So, look, if you bond out on the resisting, then you go to arraignment court, they give you a plea offer, decide if you want it or not, and, or if you want to talk to a lawyer.
Your Honor, Mr. Solis would like to plea to the resisting officer without violence, the charge before you, and then, as we requested, take no action on the out on bond case because he does have a
Okay.
valid driver's license.
I understand what you're saying. Sir, is that what you want? You want to plead it out?
Yes, ma'am.
All right, I'm sorry, I misunderstood when I thought you wanted to bond out and go back to court. You want to get it over with for convenience sake because you think it's going to be the same thing anyway?
Exactly what my PD just said.
All right, all right. Did I get you sworn in yet? Did you raise your right hand yet? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down. Okay, sir, did you read the plea form?
Yes, ma'am.
And you understand you're giving up your right to bond out, go to court, talk to your lawyer, and figure out if you want a trial or not? Right.
Yes.
And if you want a trial, the state would have to prove beyond a reasonable doubt that you resisted an officer by not doing what they told you and wasting a bunch of time, and the jury would have to be unanimous in their belief that, it rose to a level of resisting charge. You understand that?
Yes, ma'am.
You won't be able to take the stand and say, well, no, I just needed to pee, and that was all that was happening, and, I didn't really resist, or whatever else that you would say. Because supposedly the officer said that. You said that.
Right.
So you won't get to have a defense, and nobody will argue on your behalf. Any questions about your rights?
Ma'am.
All right. Okay, so I find that you are, and if you were on probation, this would violate your probation. If you're not an American citizen, it'll cause deportation. You understand that? All right. I think that you are doing this freely and voluntarily. I think you actually have thought about it, and you want to resolve it because it's probably easier than coming back to court. And there's a factual basis to accept the plea. So I'll accept your plea of no contest. And I think they had offered you an adjudication on the resisting charge, credit for 2 days' time served, release you as to this charge. Court costs are 300 and something. We'll give you a year to work on that. You can make partial payments through the clerk's office, website if you want. We'll take no action on the driving license suspended, because that's the one you want to go back and prove that you've got your license back and see if you get better deal, right?
Yes.
Okay, make sure you make all your court dates on the driving license suspended.
Okay.
Sorry for all the time I took on that. All right. Is this Ms. Fuller?
Yes, ma'am.
Thank you, ma'am. We have case number 21MM340380. We can appoint the public defender to represent you. And we also have case number 21MM340, 2021 MO 2549 and 3403. I think the pretrial release person might be recommending mental health pretrial release.
Your Honor, yes, they did qualify her.
Okay. And she's on meds.
On a warrant and a new law?
Yeah, I mean, if it's mental health, it's mental health. And you weren't gonna offer a plea because it's a battery and assault anyway, right?
Yes, Your Honor.
Okay. Ma'am, are you understanding everything?
Yes, I have to come back to court.
Yeah,
Okay,
we're gonna give you a public defender,
okay.
and I probably should, create alternative, bond or mental health pretrial release, although we think she's going to qualify, but these cases involving assault and battery, I'm a little bit worried about it.
I'll come back to court.
All right, would you like to have some mental health treatment services while you're waiting court?
Yes, please.
Okay. Sounds appropriate.
Tomorrow, weekday? Monday.
So one of the people involved in regard to an alleged battery and criminal mischief was a Richard Phillips, and we're going to need to say no contact with him while you're out. Do you understand?
Yes, ma'am.
Separate residences, I don't see anything related to this being domestic, but
For the clerk, Richard Phillips is the victim in the 21MM 2549 case.
yeah, Richard Phillips. No contact with Richard Phillips while you're out.
Yes, ma'am.
And let's put I don't see a whole lot of criminal history, and it's a mental health case, so let's authorize mental health pretrial release if eligible, or bonds authorized to be changed by Judge Kranek. So bonds on the criminal mischiefs counts 1 and 2 at 100 and 500 on count 3. And that's just an alternative if she, for some reason, doesn't qualify for pretrial release.
There's also another victim in that 2549 case, Flora Williams.
Okay,
I'd ask for no contact with both victims.
both victims. Did you need that one spelled or anything? Or no? Okay.
And
thanks.
no return to the residence.
No return to that residence.
Yes, ma'am.
All right, and then the new one is 2021 MM3403. In regard to the criminal mischief and assault, will find probable cause, no contact with Janice Vaughn, Vaughn,
Yes, ma'am.
and no return to that residence. And that's authorized as either mental health pretrial release if qualifies, or if does not qualify,
Your Honor, Janice Vaughn is not the alleged victim in that case, it's Miss Cook.
She what?
Miss Cook is the victim in this case, not Janice Vaughn.
Ms. Cook. Okay, thank you, Ms. Cook. And then criminal mischief would be the 500 and the assault would be 100. So she's got some monetary bonds if she does not qualify for mental health pretrial release. Don't have contact with them, ma'am. Now,
Okay, yes.
if you get out on the mental health pretrial release, and you're also going to have a public defender, they will help you with some medications and services, and maybe that would be helpful for you. All right, good luck.
Thank you.
You're welcome. Okay, is this Mr. Neesmith? All right, sir. We have case number 21MM220180, and we'll appoint the public defender if you need the public defender. It's an alleged failure to appear on a trespass case, bond amount $2,000. Are you all pleading those out, or are you just?
No, Your Honor, this was an actual true victim case. It came in as a burglary and criminal mischief.
All right, and there is some background. So, okay, sir, you need to be careful with your court dates. If you don't come back, you'll probably get a plea offer at arraignment. Hopefully, they will have contacted the victim by then. Okay, is this Mr. Brown? All right, sir. We have,
We have an offer from the state on these next two, Your Honor.
I can't hear a word you're saying, sir.
We have offers from the state on these next two ordinances.
Okay, thank you so much.
Do we or don't we?
They're city ordinances, so yes.
So what would be the offer?
I've been authorized by the city to offer a withhold and credit time served.
To offer what?
Withhold and credit time served.
All right, how about I just tell him one time instead of we do it twice? If you haven't had a chance, and if he needs some help, we'll let you do that.
I'm good, man.
All right, it's 21MM593. All right, so thank you, Mr. Brown. The lawyer's there for you if you need him. He wants to, be available. But you heard the withhold and time served, and that seems to be the magic number, right?
Yes, ma'am.
Okay. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. 51 misdemeanors. All right, so, sir, did you understand you'd be giving up your rights to have a trial on the case?
Yes, ma'am.
You won't have anybody checking out your case for defenses or technical defects in the state's evidence. You understand that? The state won't have to prove it. And if you were on probation, it would violate your probation. If you're not a citizen, you'd be deported. Any questions about that?
Ma'am.
All right. Sir, I believe that this is probably in your best interest to just get it over with and that you're doing this freely and voluntarily. I'll accept your plea of no contest, find a factual basis, and withhold adjudication, give you credit for time served in regard to drinking a beer. We do impose the court cost of $300 and give you a year to pay in case you need help in regard to partial payments. And that's it for now. Thank you.
Thank you, ma'am.
They're looking at you guys. They don't even know who the judge is. Because the judge is offset? Or because you look so much like a judge? I think they probably wonder what your voice is like, Because, is this Mr. Nguyen?
Yes, ma'am.
Okay, thank you. Sir, we have a case called disorderly conduct, 21MO594AO, Division 62, and that's Mills and Colonial.
Your Honor,
Oh, that's you. Okay.
Your
Yeah,
Honor.
you've been walking up and down there for a while. Never mind, you don't have to say anything about your case.
I spoke to Mr. Nguyen about the state's offer of withhold and credit time served.
Yeah.
I wouldn't, as a friend of the court, I spoke with him. I advised him not to take the plea, but he informed me that he would like to enter a plea. But I told him specifically certain instances of the effects of entering a plea.
Is he not a citizen?
That may have been one of the issues, Your Honor, and so I can't say that as a friend of the court that I would take that plea, but he has told me otherwise.
Well, he does not have a virginal record, put it that way.
I understand, Your Honor. I'm just speaking about these charges in front of us.
Oh, okay, so like, you'd rather fight it?
No, that's my,
Half of Orange County has seen him at that light.
Mr. Nguyen has a different opinion than I do. That's all I'm saying.
Okay,
Mr. Nguyen would like to take the plea. I advised him to not take the plea, but he still wants to take the plea. And I spoke with him as a friend of the court.
they didn't charge him with a pot because it's too hard to prove for 1 gram, okay. All right, well, Mr. Nguyen, did you want to resolve it even though the public defender wants to have a trial and have fun with it?
No, ma'am.
Sir?
No, I want the plea guilty.
I also think Your Honor, I also think language might be an issue.
Oh, okay.
Our notes suggest that he needs an interpreter, but he's not listed as one.
What's your first language?
Oh, Vietnamese, ma'am. Vietnamese.
Vietnamese? All right. Do we do language lines?
They're gone, it's 12:30.
Well, I can't even understand one word he says, to be honest. I'm sorry, we're getting late on this. It'll be fast once we get the interpreter. And then he, you want to do that while we're waiting for the interpreter?
Yes, Your Honor.
Oh, okay. All right, well, just a minute, hon, sir.
Hampton, 21 CF 4342, filed yesterday.
Okay, motion for ROR denied.
Toronto, 21 CF 4369, notice of non-filing.
Motion granted.
Sanat, 21 CF 4473, notice of non-filing.
Okay, motion granted.
Highfill, 21 CF 2529, notice of non-filing.
Okay, motion is granted.
Strong, 21 CF 4387, notice of non-filing.
Motion is granted, thank you. Does it take a while to get the interpreter? Do we know? You got it, thank you. Do I have to put teleconference? Okay. Good afternoon. This is Judge Blackman in Orange County Court. Is this the interpreter for Vietnamese?
Yes, it is.
Thank you so much. Do we need to swear you in? Or you've been sworn in today?
I have not been sworn in.
Okay, do you swear to faithfully and truly translate from English to Vietnamese and Vietnamese to English?
Yes, I do.
Thank you so much. We have a Mr. Nguyen, and his case number is 2002-1 MO 59480. We already started to talk about it. I think he understands English, but I was having a hard time understanding him.
Yes. Xin chào anh Nguyễn. Thì có hồ sơ của anh 2001 rồi MO 59480 thì hình như anh có hiểu tôi nói, nhưng mà hình như là sau khi anh nói trả lời tôi thì tôi không hiểu nhiều cho lắm.
Dạ. Ok. Cảm ơn anh. Biết rồi.
Yes. Yes, I understand that.
Okay. Now, did you get a chance to look at a plea form in English?
Anh có nhận được cái đơn để thương lượng bằng tiếng Anh không vậy?
Có.
Yes, I have.
Okay. Now, I can't remember, did we get you sworn in to tell the truth yet?
Chúng tôi có tuyên thệ anh vô chưa? Hồi nãy giờ.
Chưa.
No.
Would you raise your right hand to be sworn in to tell the truth?
Anh giở tay phải lên để tuyên thệ đi anh, những cái lời khai sự thật đi.
Dạ.
Do you swear to
Yeah.
do you swear to tell the truth, the whole truth and nothing but the truth?
Anh có dám tuyên thệ những cái lời khai sau đây sự thật, chỉ sự thật không thôi không?
Được, dám.
All right, thank you. You can put your hand down.
Rồi để tay xuống đi.
Now, sir, when you read the plea form in English, are you able to understand that?
Khi mà anh nhận cái đơn bằng tiếng Anh mà có thể mình nhận tội hay không nhận tội đó, anh có hiểu cái đơn đó nói gì không?
Hiểu.
Yes, I did.
Can you understand what it says?
Những cái đơn đó anh hiểu nó nói gì mà phải không?
Hiểu chút đỉnh, giống như nếu mà nhận tội á thì mình không có quốc tịch thì nó trả về nước vậy đó.
Well, from what I understood, what it said that if I plead guilty, it might affect my immigration status. That if I was not the U.S. citizen, I might be deported back to my country. Is that right?
Yeah, you do have a criminal history, so, I mean, it's extensive.
Đúng rồi, thì mình cũng có một cái tiểu sử vấn đề phạm tội đó thì nó cũng khá nhiều.
So, we will always tell you that every charge can cause deportation.
Thì chúng tôi trách nhiệm là báo cáo cho anh biết là mỗi khi mà mình nhận tội đó thì nó có cái cơ hội là sẽ bị đuổi về cái nước của mình đó, phải không?
So it's up to you to decide whether this is, the last straw that causes deportation to happen.
Thì cái đó tùy anh. Nếu mà anh nhận tội thì cái tội mà anh nhận đó nó có thể là nó sẽ đủ cái nguyên cơ để mà có thể mình bị đuổi về đó, phải không?
And you can decide whether to take the risk of deportation or whether to bond out and consult with an immigration expert before you deal with this case.
Thì cái đó tùy anh. Nếu mà anh nhận tội đó thì cái nguy cơ cơ hội có bị đuổi về Việt Nam hay không thì cái đó mình có thể là bị hoặc là không chưa biết. Nhưng mà anh cũng có thể là anh trước khi anh nhận tội hay không anh nên cố vấn với luật sư chuyên môn về di trú coi họ nói sao trước khi anh quyết định là có nhận tội hay không.
So if you decide to accept the time served offer, you're basically saying, Judge, I'll take the risk of deportation.
Nếu mà anh mà đồng ý cái vấn đề thương lượng của chúng tôi mà nhận tội đó, mà coi như là bớt lại cái thời gian mà mình phạm tội đó thì anh cho rằng là anh nhận tội rồi có vấn đề bị trục xuất, có sự nguy hiểm nó xảy ra.
And if you decide to take the time served offer, you're also saying, Judge, I understand I have the right to have a jury trial, but I'd rather get it over with today because it's faster.
Thì cái đó tùy anh. Nếu mà anh nhận tội thì nó nhanh hơn, cái hồ sơ này nó sẽ giải quyết nhanh hơn, nhưng mà cái sự nguy hiểm là có thể là bị trục xuất, cái đó mình chưa có biết được.
Nói nhận tội, anh nhận tội.
Again, I would like to plead guilty.
Okay. So did you understand that? Let me ask you a couple more questions. Did you understand that you won't have a trial? Nobody will have to prove that you were basically panhandling at that time?
Một lần nữa, trước khi nhận tội phải đi cho hỏi là những câu hỏi cho anh hiểu rõ rằng là khi nhận tội anh bỏ đi cái quyền lợi là ra tòa để mà kêu bên kia nó chứng minh là mình có tội. Anh hiểu cái điều đó phải không?
Dạ.
Yes.
And that, the lawyers would try to defend you and present defenses and technical objections to the state's evidence. The jury would have to be convinced that the case was proved before you could be found guilty. Do you understand all that?
Và anh cũng hiểu là nếu anh không có nhận tội thì anh có thể mướn luật sư của anh có thể đứng ra để mà biện cãi cho anh và có thể bác bỏ những cái tang chứng hay là những cái sự cải biện bên kia mà nó gắn tội cho anh cũng hiểu cái điều đó phải không?
Dạ.
Yes.
And you're willing to give up those legal rights in order to finish your case today?
Và anh sẵn sàng bỏ hết tất cả những cái quyền lợi hồi nãy tôi nói và vẫn nhận tội để mà cho xong cái hồ sơ bên ai phải không?
Dạ.
Yes.
Okay, sir. I find that you are actually alert and intelligent and that you are entering your plea of guilty in a free and voluntary manner.
Rồi tôi đồng ý cái sự đồng ý của anh là anh tự nguyện và anh hiện giờ tỉnh táo và anh tự nguyện nhận tội bên đây.
Tỉnh táo không có gì hết.
Yes, I'm very alert right now and nothing making me to make a decision.
Anh nói bà là em cảm ơn bà chấp nhận xin nhận tội này. Cảm ơn bà nhiều.
And thank you very much for accepting my plea today.
You're welcome, sir. We'll accept your plea, find a factual basis, and I can't remember, was that was it withhold? Okay. Time served, 2 days?
2 days.
Okay. Now,
Rồi, không có gì.
Yeah, go ahead.
Thì cảm ơn anh thì cũng đã đầu thú như là nhận tội bên ai và chấp nhận có hiệu lực bên ai luôn.
Ok, cảm ơn anh nhiều.
We always
Thank you so much.
We always apply court costs. They're $300 and something, but we give you a year to pay and make partial payments.
Thì cũng như anh biết là sẽ có phạt tiền là 300 là mấy chục đồng đó, thì chúng tôi cho anh tới 1 năm để mà anh trả nha, chia ra nhiều lần để trả nếu không đủ tiền trả lần.
Ok.
All right, good luck to you, sir. Thank you.
Rồi, chúc anh may mắn nha.
Thank you. Okay. Thank you to our interpreter. Thank you so much, sir.
You're welcome. You have a good day, Judge. Bye-bye.
You too. Thank you. He's out there every day. I go
very happy.
all the time. All right. Did we get through the morning? Thank you so much. All right, is the private attorney waiting for somebody to be called up?
He's here somewhere, Judge. Oh, there he is, Jamal Watson.
Okay. Is that him on top?
Good afternoon.
Okay, thank you. Let's see, let's go ahead. How are you doing, Mr. Natari? I almost didn't recognize you with the
I
mask.
know, with the mask up.
And you're wearing greeters.
I know, right.
Welcome to the
Tell me
Old
about
Age
it.
Club.
I know. I know.
All right. What have we got on Mr. Watson? And I don't even know if I got that far. All right, he's got a few things here.
Does, Judge. We were actually here last week on the original charge. There were some original charges, after which they executed a search warrant and came up with these charges.
All right. Did you talk to state about the timing of it? And are they in agreement that he didn't violate the release conditions on the old ones? I think that's what the allegation is.
No, Your Honor. I mean, it's a resisting without and then a warrant case.
Yeah, there appears to be, when they arrested him at the ale house last night, the affidavit says that he tensed up when they were putting the cuffs on him, and that was why they want to hold him.
Oh, okay, the resisting?
Yeah.
All right, the resisting is 21 mm 3433. Fence embrace, placing in handcuffs. Used his body weight to pull away. Okay. Right, and the ones that are the subject of the warrant, I guess. Is that the only new one? 2021 CF 5750. Okay. Possession of trafficking in MDMA over 400 grams.
What it says, Judge.
Mm-hmm.
And then they have $100,000. Then on the next one, they have trafficking with a weapon.
None until IAs, that's pretty normal. And then some others, and, none till IAs, okay, all right. So, did the state want to be heard on that?
Your Honor, I would ask that you stay the bonds that they're currently set on the warrant and set a bond on count 2 more than count 1, as there is an allegation of a weapon.
I don't think.
I believe it is potentially a life offense, Your Honor. The trafficking in meth is an F1. I believe the weapon makes it a life offense as it enhances it. And if Your Honor is inclined, state would ask for no bond, given that it is a life offense.
On the ones he's out on?
On count 2.
Oh, if I was inclined, you'd ask for no bond?
Yes, Your Honor. Otherwise, I just ask for a high bond higher than count 1.
All right, well, you got your hands full, Mr. Natari.
I see that, Judge.
I mean,
This is obviously this occurred, he wasn't out on bond when these occurred.
Right, I got that.
So I asked the court
The
to,
only thing he supposedly did while he was out on bond was
Tense up,
tense
yeah.
and then not, really make it easy for them to get him in the car. And I get all that. But he's got a lot going on just in the one with a warrant. I mean, the 100,000 and he's asking for no bond. Any suggestions on that one?
Judge, I would ask the court to set, maybe count 1 at 50. I think his family, his mother's coming in from Georgia to help him tonight. And probably 10 on count 2 and leave the rest where they are.
Your Honor,
he's
he's
got-
object. He had a significant amount of drugs on him of all different kinds. He is a convicted felon. And I don't know if you looked
At his
on
history?
his history is also page 4 of the warrant, them detailing everything that was found.
Right. I've read the warrant, Judge.
It was lots of ammunition, lots of guns. It wasn't just a single firearm for protection. It was many firearms, many different rounds of ammunition, many different things to suggest that he's selling and delivering.
Okay, give me a second. Mr. Natari, wouldn't it be better if you just take this to the judge who's going to handle it? Because I don't know what they're doing on these right now.
They're allowing, I believe they're allowing to have Arthur hearings right at the jail. I've had a few here, which I will tell the court, having heard the state, that if you read this is a joint occupancy. He occupies the home with someone else.
Well, somehow I didn't
Still
get.
joint possession, Your Honor.
Is there a problem getting a hearing downtown? Can you just get a hearing,
It
like
takes a
right
week.
after the weekend?
It takes a week or two.
Takes a week,
It does.
because problem is, his mother's gonna put up money. I'd rather just be stable. And holy cow, look at all this stuff they've got, allegedly, in that car.
Well, no, it wasn't the car,
No,
Judge.
that was a
That's all in
house.
the home, that
home.
he
I'm sorry.
occupies jointly
Yes.
with someone else. So without any other indicia of possession, there's two people occupying this house. It's the old, you and I are driving down the street, there's a brick of cocaine in the console, who's it belong to? And at this point.
Looks like it's all over the place, so that's another whole issue.
Yeah,
Okay. Honestly, I just don't want to, I've got a million cases. I don't want to have a bond hearing today. And I think that the felony judge is going to do whatever they're going to do anyway. I can't really help this young man. I know you can. He's in fine hands. Whatever the best that can happen, you'll probably get it downtown. I just want to leave it the way it is. You can tell the judge there, I just didn't want to make a decision. I don't like to shove work on them, but this is a lot. And I don't know what these felony judges are doing with these MDMA cases with the large quantities and things like that. So let me not touch the ones he's out on bond for. So at least I simplify it in that
Okay.
regard. Because I understand the state's request, but I understand you're saying he was tensing up, Judge. It wasn't like he flat out, another really big crime. So but I'll leave this stuff, leaving it at no bond it's not, the concern is the safety of the community, but also really just wanting the felony judge to do what they're going to do anyway, to be honest with you. And I know you'll get him in court within about a week. So let's just do that. Sir, you need to give your mother a break before she has to mortgage her house. Good luck.
All right, thank you, Judge.
Your Honor, just for the record, you're going to stay the bond on the resisting at 500 on 21
Sure.
MM 3433?
Yeah, thank you for that.
And you're going to stay the bonds on 21 CF 5750 at 100,000, 0, 500, 4,000, 4,000.
Yeah, for now.
50, 250?
Yes, sir. Thank you.
Your Honor, you need to set a bond in count 9. He is entitled to a bond on that count. There's 10 counts.
Yeah, there's another one with a possession of
Possession of a firearm and commission of a felony.
Oh, I see that now.
I believe the bond is generally, I think, 4,000 on that, Your Honor.
Well, Judge, everything else as you get lower starts to become 250 with the larger bonds at the beginning.
just the 150 on that. That's enough. It's just academic. Thank you. Okay. An interpreter? Thank you.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Interpreter, previously sworn.
Thank you very much, Mr. Morales. Might need you to speak up just a tad bit. We have Mr. Diaz. It's an add-on case, case number 21 CF 5908. Going to Division 16. He might already have the public defender on another case. So I'm assuming we need a public defender on this one. Okay, sir, I don't know if you want me to say very much about what this is. Would you rather me skip the name of the charge?
No. No.
You said no?
He said
Oh, I didn't understand.
So it's an embarrassing charge. I'll name it if you want me to, and I'll skip the name if you want me to, if you know what it is.
Como sea. However,
Your Honor, I would just ask that you read it. I don't think he understands what waiving the reading of the charges means.
All right. It is a warrant for your arrest in regard to an alleged sexual battery on a child under 12. It's alleged that the other stepdaughter said that the same thing had happened to her at one point a while back. And so you have a charge added in regard to that. And obviously, we're going to order no contact with the child or witnesses.
Your Honor, this is a capital offense. It is punishable by life. State would ask that you hold him no bond pending an Arthur hearing. He is also sitting no bond on the other case for the 2-year-old child on the same charge. State has already filed an information in that case. It is currently, yes, it is currently set for an Arthur hearing downtown on June 9th.
Okay.
So I just ask that you hold this one no bond as well, so this one can most likely be heard when that one's heard.
All right.
No argument, Your Honor, pending that Arthur hearing.
Okay. So let's leave it at no bond for now. You have a hearing on June 9th. We'll appoint the public defender, and hopefully they'll bring both of them to court on the same day.
I'll email the ASA right now so they can consolidate, Your Honor.
Good luck, sir. Do we have one or two more interpreters? Two more at least. Okay. Mr. Morales, we got a little more. We were busy today.
No problem.
The next one is Ms. Fernandez Sanchez. And this, she's got three things. She's got a I think it's case number 21 CF 588680, Division 19. Possession of cocaine, and some other things. We're going to appoint the public defender. In regard to the possession of cocaine, there's a probable cause on these charges. Bond would be $1,000. Possession of oxycodone, bond is $150. Alleged destruction of evidence, bond is $150. Alleged false info, the bond is $100. Alleged resisting, the bond is $100.
State would ask for no drugs or alcohol without a valid prescription.
Okay. In regard to 2021 CF 588780, it's an alleged driving with license suspended while on habitual traffic offender status. They have enough information to file it, and the bond is $2,500. The third and fourth cases are violation of pretrial release conditions out of county in Volusia County, and I believe those are driving with license suspended, possession of paraphernalia. There's two of those cases, and each of those has a $1,000 bond. So you have a few, right?
Your Honor, I believe she also, the two cases that both have 1,000, so it's 500 on each count on each case?
Yeah, probably. You need clarification on the out-of-county warrant?
I currently have it set at no bond on my.
Out-of-counties?
Yes, Your Honor.
They're at 1,000 each.
1,000 each.
Okay.
All right. Ma'am, good luck.
So do I have a bond or no?
You do, but you have several. It's starting to get complicated when you get a lot of cases, ma'am. Good luck. Then we have a Mr. Ochoa. right, this is case number 21 CF 5924, an alleged carrying concealed firearm. Let's appoint the public defender first. In regard to the carrying concealed firearm, going to Division 16. It appears that they have enough information to file that charge, and the bond amount is $1,000 on that. They also,
Your Honor, on that one, state would ask for no weapons or firearms or ammunition without,
or without a permit.
yes, Your Honor.
Okay. There's a no valid license charge, but I'm not sure about the case number on this. Wait. Is that supposed to be a CT? It looks like a CF on the license charge. Is it 21 CT 3609, Division 84?
Yes, Your Honor. 84 is Judge Jewett, which would be in a CT.
Okay, so it's a CT instead of a CF.
Yes, Your Honor.
All right. Now, so did they just do no valid? They didn't do suspended, or did they do both?
No, Your Honor, just a no valid.
All right, sir, be careful on the suspensions because that can be upgraded and you want to pay the things, you know, even if it's hard, work on that, pay them. Even part payments are better than nothing. In the meantime, you're out on bond, so we'll leave the bond at 500 on the new no valid license charge. But you're also out on bond. And he's a high school student? Wait a minute, how old is he? No, he finished high school, now he's in construction, okay. All right, so he's out on bond for no motor vehicle registration and no valid license. So what happened was they were checking the situation and they saw warrants. Did he see warrants or it was just? Are there any other warrants?
No, Your Honor.
Okay, I don't know what he saw then when he decided to pull him over.
He had extremely dark tint, Your Honor. And the windshield was tinted, which is against Florida statutes.
All right,
Your Honor, in regards to his out on bond, state asks that you revoke and double, setting both at 1,000.
He's young. I think he's trying to work. I'm just gonna double one of them. On the other driver's license, or driving without a license charge, 2021 CT 1543, we'll revoke and double it to 1,000. The other one, I'm not gonna take any action. You're young, you need to deal with your license. I don't know why you're carrying a gun, but you know, you need to start following the rules or you'll just keep getting behind. It becomes a snowball. It's a real mess. But if you're extremely strict at following the rules, you won't have these problems. Good luck to you. But they're looking for drugs. They're going to pull you over just for windshield tint. They're going to pull you over for, not stopping on the stop bar. Tell them, be careful. I didn't revoke on no motor vehicle registration, just only the valid license, and I just doubled it to 1,000. The one about the registration, I just let that go. Is this, I think we have one more. Is this Mr. Lopez? This is an interpreter case too, right?
No, Your Honor. I speak the lingo.
That was the last one. Thank you, Mr. Morales. We're finished.
You're welcome, Mayor. Thank you.
Yeah. So, All right, so Lopez is just a move up then?
Yes, Your Honor.
All right, thank you. So this is Mr. Lopez, 2020 CF 11787, and it's in Division 20. And you were rearrested on a violation of community control. It was alleged that you changed your residence, well, without letting them know. You were away from your monitoring device, so it's now at no bond, and you'll need to check with the felony judge in regard to that. And that's all we have for you right now.
Yeah, no bond, ma'am?
Yes, yeah, they don't play on those community control.
I know, but
And
I
I
didn't
can't
violate
change-
it, Your Honor.
Sir,
I didn't violate it. I'm innocent.
I
The
can't,
doctor-
I
the
can't
doc-
change it. You're gonna have to talk to the other judge on that.
Which other judge?
Your main judge, not me. DeQuan Shields?
Yes, ma'am. How you doing?
I'm okay, sir, thank you very much. Okay. Let's see what we have is, we have a Seminole County failure to appear on a misdemeanor case.
Yeah, when they come to get me.
Don't say nothing.
But I think that Judge Schott said that if you get taken into custody, is that a ROR on that one? He's got two cases that are, two or three? Are they all ROR?
Yes, Your Honor, he should be RR'd on this.
Right, now, so Mr. Shields, you got two or three cases over there in Seminole. If they release you on your recognizance, you need to go back over there. Judge Schott is very nice, but he wants you to appear. No, I didn't, that's the name of the judge. It's the name of the judge in Seminole County. Okay, thank you and good luck to you, sir.
Oh, yes, ma'am. You can take me.
Okay, we're back to the regular docket with Mr. Abbott.
Abbott bonded, Your Honor.
Thank you. And what about Cindy Bennett? She's got a lawyer.
It's right here.
Okay, Miss Bennett. I think you've got a lawyer involved.
Yes.
And he, I think, was informed of the time of the hearing, but
He said he was going to try to do video.
oh, video? I don't know about that.
We don't have video out here, Your Honor.
Yeah, all right, well, he knows about it. So it's case number 21 CF 5743, it's in Division 20, and it's a warrant. And some of these come in, no bond until IAs. Let me make sure that there wasn't any problem with. I don't think it says that it can't be changed, but
Yes, Your Honor. Count 1 is a punishable by life offense. State would ask that you hold her no bond pending an Arthur hearing when her attorney can be present.
so what it looked like was that she is like somebody that helps with the family. She is a housekeeper, and the daughter, who is a caretaker of elderly, I guess, parents, found that a room was messed up, and also that Ms. Bennett allegedly pushed her down so hard that, I don't know you realize it, but this woman got like a bunch of breaks in her arm because you don't have to say anything about your case. You have the right to remain silent. Anything you do say will be played back at your trial, so don't say anything. But as far as the burglary itself, I was trying to figure out where that was, other than messing with the woman's room.
Your Honor,
Is
she
that-
entered without the permission to be there.
In the room? Or the house?
The house at this point, at the end of the warrant, it did say that she did not have consent to enter the residence, and she remained in the residence. And when confronted and told to leave, she also did not leave the residence, and at that time, she committed a battery by spitting on her and then pushed her, creating all the fractures in her arm.
Your Honor,
She
can-
entered without a right to do so. Then if she believed she had an invite because she'd been invited previously, that invite was revoked, and that's when a battery occurred inside twice.
So when it's revoked, it's a trespass.
Not if they remain, Your Honor. It's the
Trespass
jury,
after warning.
the jury
You're
instruction.
talking about life felony here, and that's arguable.
Your Honor, the jury, or the statute says entering a dwelling or a structure or a conveyance with the intent to commit an offense herein, unless the premises are at the time open to the public, or the defendant is licensed or entered to remain. And in the jury instruction, it makes comment as to if that license is revoked, it also can be a burglary. I can print a copy of that jury instruction for you if you would like to see it.
Your Honor, can I speak to Ms. Bennett as a friend of the court?
Sure. So, the victim had asked her mother why Cindy and her boyfriend were there, and the mother said they were working on a vehicle. So this is one where they were there, but they, stayed after permission was revoked, I think. I mean, it's hard to know that, it's not like a breaking and entering of dwelling and an assault therein, which is your life felony is the boogeyman in the middle of the night comes, stands over your bed, and you're like, ah! And this is not that. This is the housekeeper, okay? It's not your typical life felony, and I can't react to it as such. Although she has a bit of a history. She maybe isn't the best person to be around there anymore. Absolutely, ma'am, no contact. Don't go back if you have any things in the residence because you were a regular there. You'll be allowed one police escort to get your things, but don't go back in any way, shape, or form at this point. Even if this lady's parents want you back at this point because she lives there, you have to talk to your lawyer about that. I'm not minimizing the situation. I think it's a problem because you got a little bit of a history, and supposedly her arm got broke in 6 places in regard to the force from which she was either thrown down, or maybe she's got paper-thin bones. I don't know which, but it's a problem, okay? And your history, is not exactly virginal.
Your Honor, given that this is a punishable by life, but you are willing to grant bonds, they would ask for 6 figures.
All right, $2,500 on the battery to commit the felony battery because it was a nasty bunch of breaks in her arm. And on the burglary, I can't help but look at it as more of a trespass after warning, so that's a $500. If your history was any worse than it was, I'd make it a lot higher because I don't want to play with this stuff where people's bones are being broken. Talk to your lawyer. No drugs or alcohol while you're out, no weapons. Put those in the custody of the arresting office within 24 hours of your release. Make all of your court dates. Good luck.
Your Honor, so you said 2,500 on the battery and 500 on the burglary?
Yeah, because it's really a trespass. Sorry. I know that makes you mad, but it is what it is. Okay, is this Ms. Bragg? Okay. All right, ma'am. This is case number 21 CF 5937, and it alleges, and they have enough information to at least file the charge, public defender appointed. Count 1, possession of heroin with a weapon. Those have been coming in pretty high, although this is a knife and the amounts are small, so it looks really like you're a user instead of a dealer on these. And you really have a whole lot of prior drug charges, ma'am. I would feel a little bit bad about the 10,000 because I think those are usually, intended to keep drug dealers off the street. But you got some priors. You really, in fact, and failures to appear. So I don't really feel like arguing with the state on this one, especially after I just lowered the bond on the last one. So I'm gonna leave it at the 10,000 on count one, 150 on count two, possession of methamphetamine, 150 on count three, possession of fentanyl, 150 on count four, possession of controlled substance, 150 on, I don't know why it's 150 on the paraphernalia, but it's probably academic. I think the other reason is that with that many drugs, ma'am, I'm a little bit worried about you, and if it takes you a few days to get out and you have to detox a little bit, I hope you'll be okay medically, but it might actually be better for you, your own safety and welfare, all right? So just talk to your lawyers about when you can come see the judge and figure out what's next. Thank you, good luck. Is this Mr. Carrion?
He's medical, Your Honor. He is medical.
Medical, all right, let's appoint the public defender on him. It was a warrant. The judge found probable cause. He also has a very extensive history, so I'm not quite as worried about it on this one.
We'll waive the appearance as well.
Yeah, sir. So the probable cause, and we'll stay the bond, sale and delivery of fentanyl at 10,000, attempt solicitation and conspiracy at 500, paraphernalia 250, and just appoint the public defender and stay the bonds. It's Division 15. All right, Patrick Celsus?
Yes, ma'am.
All right, sir.
How you doing today?
Okay, thank you. Sir, let's go ahead and appoint the public defender first. Wait, it says not qualify? Is that how much you get per week? The 500 to 800 per week when you're working?
Yes, ma'am.
Okay. Well, technically, you don't qualify for the public defender. We're going to appoint them temporarily now anyway. It's Division 22. They have enough information to file these charges. They had like 6, including possession of cannabis with intent to sell. It came in no bond, I think, because of a weapon. And based upon the allegations, the numbers of various quantities, I was willing to set bond at 10,000 on that. And in regard to the other subsidiaries, possession of alprazolam with intent to sell, set that at 150. Possession of cannabis over 20 grams at 150. Possession of firearm and commission of felony, these are all separate counts, at 150. Carrying concealed firearm at 150. Possession of paraphernalia at 100, I'm sorry. And I did take some of your prior history into consideration, sir, but hope that that's sufficient for the gravity of the charges. Now, if you can't get a private attorney, let the judge know and be real clear about what your real financial circumstances are, because you are entitled to be represented. Even if
Yes, ma'am. Thank you.
you're welcome. Good luck. Mr. Colazzo?
Yes, ma'am.
Thank you. Case number 21 CF 5916. It's going to Division 19, counsel. We can appoint the public defender. Sir, they had enough information to at least file a charge of grand theft auto because being in possession of a stolen vehicle is enough for them to file the charge.
Yes.
Bond on that is 1,000. Make sure you talk to your public defender, make all your court dates.
Your Honor, state would ask for no contact with victims or witnesses.
No contact with victim or witnesses. Yes, sir. Ms. DeSanto, case number 21 CF 5933. Ma'am, let's appoint the public defender to represent you that had enough information to file a possession of cocaine charge. It's in Division 16, counsel, and the bond is 1,000. Make sure you come back to court for all your court appearances.
Your Honor, Ms. DeSanto does qualify for PTR as well,
She does?
according to my report.
Oh, okay. All right, all right, or PTR if eligible.
She's
Yes, no?
she's already eligible, so you just want to put her on straight PTR?
Well, she looks like she's got some priors, but if that's what she qualifies for.
Yeah, she already qualified, so it's up to you if you want to give it to her. Instead of saying like bond or PTR.
All right, PTR, straight PTR. Okay.
Your Honor, state would ask for no drugs or alcohol without a valid prescription and RUA.
Oh, okay, she's asking for random urinalysis, if you can handle that. That, when they make you pee in a glass to prove that you're not on drugs while you're out on bond. All right, good luck. She got a little history. Okay. Mr. Donnelly? Is that you? Thank you, sir. Yeah, it's case number 21 CF 5923, and we can, okay, I guess you make a little too much to get the public defender, but if you can't get a lawyer before you come back to court, let the judge know because you're entitled to be get some kind of lawyer. You have to have generally a lawyer in criminal court.
Make
Sir?
too much for a public defender?
Well, did you write 2,500 a month?
Yeah, but that's it's a stretch guesstimation, if you will.
It's a stretch. Is there a different number you'd like for me to put down?
I would say maybe, that's a good month. I'll say about 1,500.
15? All right, well, then you'd qualify, so we'll appoint the public defender. And I've just amended it for you because otherwise you come to court, you don't have a lawyer, and it's just a hassle for everybody. Okay, so we'll appoint the public defender. It looks like you might have a probation extradition out of, I think, Virginia?
Yes.
Which could complicate your getting out, because it looks like they might be willing to extradite. They did have enough information to file the charge of failure to redeliver hired vehicle. That's a $1,000 bond, and it's going to Division 17. So that's all I have for you at the moment. If you bond out on this one, and if you can get out, make sure you come to your court dates. Ms. Downs? Okay, thank you, ma'am. Case number 21 CF 5894. Let's appoint the public defender and
Your Honor, regarding count 1, state would ask that you find PC for possession of heroin, 893.136A, not possession of heroin with intent to sell or deliver. When reading over the affidavit, it doesn't appear like there was any intent to sell or deliver. There's no additional baggies or a scale or anything along those lines, nor is there a actual buy set up with an agent.
Okay.
So I believe it was incorrectly charged, so I just asked for PC on a standard possession of heroin
all right.
and set the bond at 1,000 instead of the 15,000 that's on there currently.
All right, I'm pretty sure the lawyers are not going to object to that. Let's find probable cause for possession of heroin instead of possession with intent. Bond amount 1,000 on that charge, and the paraphernalia bond is 100. Does, I can't remember if it said something, were there any other warrants or anything?
No, Your Honor.
Enacted warrant? Oh, it was somebody else.
It was the
Okay.
other passenger.
Somebody else, okay, never
Your Honor,
mind.
state would ask for a condition of no drugs or alcohol without a prescription.
No drugs or alcohol without a valid prescription while you're out on bond, ma'am. Good luck. Thank you for catching that one, counsel. Okay, is this Nora's apps?
Yes, ma'am.
Thank you. All right, sir. It's case number 21 CF 5920. It's going to Division 22 Council. Did you want a public defender? Because I'm not seeing a public defender form, but normally
No,
you
ma'am.
want to have a lawyer helping you. No?
No, ma'am.
All right, let's just give you one temporarily anyway, because there's a lot of stuff that gets kind of held up if nobody asks for discovery and all. But it looks like they have enough information to at least file the charge of possession of cocaine with the bond amount of $1,000.
State would request no drugs without a valid prescription.
All right, and don't have any drugs or alcohol, or without a valid prescription while you're out, sir. Good luck.
Thank you.
You're welcome. We have Mr. Galloway. All right, sir, let's appoint the public defender for you. We have more than one thing. We have case number 21 CF 5895 in Division 11, and it appears they have enough information to file the charge of possession of heroin, count 1, bond amount 1,000, possession of paraphernalia, count 2, bond amount 100. There's also a failure to appear warrant or capias. Looks like a failure to appear for a hearing on March 11th in Division 22, and that was on a possession of Utalone. I don't know how to pronounce it. Okay, the bond on that one is $1,500 on the failure to appear. Then there is case number, third case is 2020 MM 5181. It's in Division 63. That's a failure to appear on a petty theft. And that judge set that at no bond. Really, on a misdemeanor? That's all right, counsel for the defense. I'm not sure that's appropriate, but I'll let it go for now. But check it out if it's not appropriate to hold him no bond on a misdemeanor. I think it's
Your Honor, on 5895, state would ask for the condition of no drugs without a valid prescription.
no drugs without a valid prescription. All right, good luck. Mr. Goodman. (2021) CF 5929. is the new charge. For the record, he does qualify for the public defender. Is this Mr. Goodman?
Yes, how you doing?
Okay, sir.
Yes, how you doing?
All right, thank you very much, sir. The new case is 2021 CF 5929, in which it's alleged that, like basically grand theft at a store in regard to like 18 shoes. So they have enough information to file a grand theft charge on that with the bond amount of 1,000 and the paraphernalia charge of 100. Public defender is appointed. And you might have been out on bond for some stuff,
Your
Mr.
Honor,
Not? No? What?
they would ask for a no return to the Nike outlet.
Okay,
No contact with the victims or witnesses,
okay,
and no drugs or alcohol without a valid prescription.
okay. So as far as I can tell, you've got a number of cases that you're out on bond for. And I don't think I can save you from that many. There's just not much I can do. I think you're going to have to go face the felony judges for getting a new grand theft while you're out on bond for these. That they're still active as far as the clerk and the jail services are telling me, so I'm going to revoke you on them and let you get the public defender to try to put them all together and figure out what to do. You've got public defenders on each one of these. So I'm going to revoke on 2021 CF 2544, that's grand theft, third degree, motor vehicle. 2019 MM 2183, trespass and conveyance. 2020 CF 10766, burglary of a conveyance. 2018 CF 18328, burglary of conveyance. And
Your Honor, I just have to put on record, I think I'm obligated. On most of those cases, there are, he was found incompetent to proceed.
oh, okay. So he's just pending,
Status hearings. Conditional release.
We would request no action on those out on bond cases if he's out on ROR. If he's deemed incompetent, Your Honor, he's at a disadvantage to other competent clients.
well, I don't have history on that. It's obviously a problem because it seems he's got a side hustle of stealing stuff, which is a problem for the community, even if he gets found incompetent. But I'll go ahead, since it's been brought up, and take no action on the ones that he's out on bond for. Good luck.
Thank you, Your Honor.
Mr. Hill. All right, sir, I'm not sure what the bottom line is on these.
Your Honor, do you want to do all four co-defendants?
Well,
Because it is a joint constructive possession.
I'd have to ask the deputies if they want to deal with that, but, I mean, it would save time. The only one thing is, the two or three that I already got through already, some of these guys have like no criminal history. And then I think the last one's named Sanchez. He has some criminal history. So, and then this guy didn't have the gun. And, you know, I think there's some people who are less culpable than others, even though it's called a burglary of conveyance with a firearm, you know. I might look at these guys individually instead of just no bonding them all and stuff like that.
Your Honor, may I approach
Uh-huh,
on this?
yeah. What was that, Sanchez? I can't remember that. Spence. I think it was Spence was the one that had the more stuff. You want me to mute? Said I was going to deal with them individually. I'm looking at them as an individual human being. They have separate criminal records. There might, and I don't know, I can really figure out the various levels of culpability, but I'm just going to look on them as individuals and not just do a cookie cutter, same thing approach in regard to every bond, especially for the guys who had no prior criminal history at all. Okay? But the PD says it, you know, he just can't handle 4 of them at one time because they might all start talking, and that's going to give him a problem being able to represent him like this. So although I thought it might be easier to do it fast, but I think the public defender's concerns are valid, so we'll do them one at a time. All right. Actually, I'm not sure whose history was what. All right, Mr. Hill. So, and the other thing I was concerned about was that there was an alleged more than one burglary. So it's like 4 guys rolling around in this car, knowing what's going on. But the problem with an armed burglary, when a firearm gets involved, is the bond generally goes way up. And so I have to take the state's recommendations into consideration, although I realize you're 18, you have no priors, and that you're employed.
Your Honor, I'm just going to put it on record. Given that count 1 is a punishable by life offense, state would ask that you hold him no bond pending an Arthur hearing. He did become armed in the commission of the burglary of a conveyance, therefore substantiating that charge. So state would ask for no bond, given that it is a punishable by life offense.
Your Honor, if I may, if you're going to hold Mr. Hill at no bond, you have to find proof evident presumption great, a standard heavier than reasonable doubt.
Did you all isolate who ended up with the gun?
I believe there were multiple guns, Your Honor, amongst the different co-defendants.
Because of different burglaries?
I believe 2 of the other co-defendants are also charged with carrying a concealed.
Okay, and those were the ones that might have had them on their possession?
Yes, I believe Mr. Winston was sitting on the firearm. I believe
Right.
Mr. Spence, I believe, is the one that fled and also had a firearm.
Right, okay. All right, sir. I think I've already told you several times what my concerns are. Now, we're going to appoint the public defender to everybody, but you can't all have the same public defender. So what's going to happen is they're going to file motions to withdraw and appoint conflict counsel on several of these, and that creates some degree of confusion as the paper goes around to the different lawyers, and some of y'all will meet your lawyers before others. But I understand the state's request in regard to the first degree punishable by life in prison, but I'm going to set it at 5,000 on the burglary of a conveyance with a firearm. Because I'm not sure who's the most culpable, and because you're young and because you don't have any priors. In regard to grand theft, third degree of the firearm, there's enough information to file that. Its bond is 150. In regard to the criminal mischief, I'll set bond at 100 on that. And the state's probably going to ask that you have no contact with any of the alleged victims of, this particular burglary. The other thing I should tell you, sir, here's something else that you need to know. What really happens is if there were a string of car burglaries, is they will file one every day for all the cases that they can get evidence on. And so whatever properties were in the car, they're going to hook them up and attach them to the various cars that were burglarized. And so it's going to seem very strange but you might bond out and then get picked up again because they find another, piece of evidence in regard to another burglary. That could happen several times, and that is exactly what happens when there's a string of burglaries, so it might be inconvenient. So we'll appoint the lawyer for now and be aware that some of the lawyers are going to be changing because you all have to each have a different lawyer, and that creates confusion also. No guns or weapons while you're out on bond.
Your Honor, state would also ask for no contact with witnesses or co-defendants, a no return to the area, and no weapons or firearms.
Okay, I think I said those, but we'll say it again. Good luck, sir. All right, Mr. Jarrett. Mr. Jarrett, let's go ahead and appoint the public defender in regard to this. It's case number 21 CF 5893, and they had enough information to file grant that motor vehicle with a bond amount of 1,000, false ID with a bond amount of 100, driving while license suspended with a bond amount of 150. You're out on bond in regard to case number 2021 CF 2605, which is also a grand theft motor vehicle. And taking into consideration your criminal history, sir, I feel certain that the judge for whom you have that case pending would want. Was that case ever filed? It looks like a ROR on that.
Yes, ma'am, it was an R&R.
Hold on.
Should we look that up? Was it a 33-day motion?
He bonded.
In 2605,
Well,
He bonded on that case.
yeah, it's the amount of $1,150.
well, okay, then let me point something out and just check. Okay. I see two things. I see the 1,100, I see a little. Tell me.
Your Honor,
It's not subject to
I only have information from pretrial services.
I can take a look again.
that has been filed. It still exists.
Your Honor, my computer just did an
All right,
update.
could we look up, I'm sorry, I don't want to no bottom on one that didn't get filed. What do you got? It's 2021 CF 2605. Did it get filed? That's an ROR. He's on a 33-day. Did it subsequently, was there any complaint or information filed?
Oh, that was a RR.
My computer did an automatic
They've
update.
never filed a charging document on it, so.
It was an RR.
Yeah, it was an ROR, they didn't file charge. Well, that's your lucky day, sir, because I was gonna no bond you on that. But they haven't filed it, so I won't. Good luck.
Appreciate it, Your Honor. I appreciate it.
You know what? All I'm doing is what's correct procedurally, but based on your criminal history, you'd be in the bag. I'd send you downtown.
And I know I deserve it, Your Honor.
Well, I mean,
Absolutely do.
well, you know, if you can say that much, then maybe there's a shot that you can turn it around, and I hope you do, sir.
Yes, ma'am.
Good luck.
Thank you.
Is this Miss Johns? Okay, ma'am, thank you. Let's see. We have a I think this first case we have is case number 2020 CF 13603. That you probably already have a public defender on all these. This one's in Division 10. It's, that was a possession of fentanyl, cocaine, drug paraphernalia, and it was a failure to appear for a case management conference on 5/13, and that judge no bonded you, so you'll have to go back and talk to that judge about that. The other ones that you're out on bond for, I don't know that this failure to appear really requires those bonds to be messed with, unless you want me to come off the bond so you're getting triple credit for time served. No?
Those out on bond cases, I believe, were no files. There's a 33-day motion.
Oh, thank you for
Out on
checking on
RR.
that, because I don't want to arrest her on that. Okay,
At
so
least
you'll
on,
need,
at least on 21 CF 4290.
all right. So I'll take no action on those because you got to go back to Judge Bleckman on the one that you failed to appear on. And you've already got a lawyer. Good luck. Mr. Landry?
Yes, ma'am.
All right, sir, thank you. We have 2019 CF 2801, and this is in Division 22. It's a warrant for failure to appear for a violation of probation status hearing on October 6th, and it says no bond until defendant appears back in front of that judge, so that's the status on that particular case. Do you already have a public defender on that? Okay, so you've already got counsel. You got to go back to that judge, sir.
Okay, you know when that is?
No, I don't. I'm doing the best I can just to read out the charges. June 3rd, says the clerk.
June 3rd.
Mm-hmm. Is this Mr. Langton?
Yes, sir. Yes, ma'am.
That's okay, no problem. It's 2021 CF 5934 is the newest case. I'm looking for a public defender application. Do you want a public defender?
Yes, I haven't seen nobody.
All right. Well, fill out one of those forms if they give you.
I had a bar lawyer because I'm involved in a case that has a lot of people in this jail. I don't know that. Man.
Well, they don't just naturally take on every new one that you get. So let's go ahead and appoint the public defender, and if you don't mind, if somebody gives you a form, go ahead and fill that out.
Yes, ma'am.
They had enough information to at least file the charge of possession of alprazolam with the bond amount 1,000, paraphernalia 100, cannabis 100. That's going to Division 17.
You would ask for the condition of no drugs or alcohol without a valid prescription.
No drugs or alcohol without a prescription. Then we have case number 21 CT 3690 in Division 63. It's a driving while license suspended charge. And they have enough information to file that, so the bond amount is $500 on that. And then the third thing is that evidently, the officer, when he ran the teletype, found out that you're on probation in Seminole County. And Seminole County case number 2001-128 for possession of controlled substance. So he filed an on-view violation of probation. And that's just to keep you in jail. That's a no bond situation, but it keeps you in jail until Seminole does their paperwork, because it's going to happen anyway.
I had my probation transferred to Orange County.
All right, but violation of probation, I'm sorry for that noise. The violation of probation is probably going to be handled back in Seminole.
Yeah, I mean, 'cause I literally just signed 2 days ago for probation. I haven't.
Well, that's not necessarily a good thing if you got violated already and you only made it 2 days. Good luck with that.
Yes, ma'am.
Okay. Mr. Lawson?
Yes, ma'am.
All right, sir, let's appoint the public defender in regard to an add-on case, 2021 CF 5917, going to Division 12. Sir, this was, you've already got some stuff going on, I think, but this,
Your Honor, I'm not sure if it is an add-on.
oh, really? Is this not the one,
I
wait a
don't see
minute,
an
that's from
add-on.
21 April, and it was a surveillance video that they supposedly, I think, saw a bicycle theft, and maybe was that UCF? UCF?
Your Honor, I believe he just has other bicycle thefts from UCF, if I remember correctly. I think that's why it was designated as an add-on.
Well, this is one where they had a bicycle theft, and maybe he's just got one more. This one's from April. They supposedly have him on video, and the UCF police officer says that they know this guy because, you know, they have seen him before. So they just added another charge.
George?
Yeah. And they called it criminal mischief, bond amount 1,000 and petty theft, 2 priors, 150. But I think you're in there on some other stuff anyway. So this is just another one. You know, some of those areas have video.
Your Honor, state would ask for no contact with victims or witnesses and a no return.
Okay. So ordered. All right, Mr. Lopez, I think this, we had several young men with this case, and it might involve more cases before everything gets done. It's case number 2021 CF 5902. We're provisionally appointing the public defender, although I don't have a public defender application form. If your family or you want to get a private attorney, that's fine. You're entitled to be represented. We appoint them right at the beginning just so the whole process can get started. And it's going to be a little confusing with the lawyers if you're not getting a private attorney and the public defenders can't represent all 4 people because they might start pointing fingers at each other. And so that they can't ethically represent all of you. And so it starts a process where basically the clerks and the judges start appointing other attorneys so that each person charged has their own attorney. But it sometimes gets a little confusing figuring out who your attorney is because sometimes it doesn't happen immediately that you get the attorney that you're going to end up with. And that's why we appoint the public defenders so they can start some of the preliminary requirements to get information from the case, and then they'll give it to the other attorney. But that might take a little while. Okay?
Can I say something? I think my mom said she was gonna get me a private attorney.
All right.
Your Honor, for the record, again, count one is a PBL. State would be asking that you hold him no bond pending an Arthur hearing. He was in joint constructive possession of the firearm. He did commit a burglary of a conveyance due to principal theory, depending on which of the 4 co-defendants actually entered the vehicle and took the firearm out of it. They did become armed in the commission of that burglary of a conveyance. Therefore, having PC for count 1, and then was found in possession of recently stolen property. For all those reasons, state would ask the court that you find PC for count 1 and hold him no bond, given that it is a PBL.
Your Honor, if I may, if you do hold Mr. Lopez at no bond, you must find proof evident presumption grade a standard higher than reasonable doubt. Again, no criminal history, almost in the same situation as one of the previous co-defendants, so for your consideration and your bond determination.
Right. Sir, I did set a bond for one of the other co-defendants who I noticed did not have any criminal history and was very young. And I didn't see, although I was reading this report really fast, that either he or you had possession of a gun.
Your Honor,
Yes.
Mr. Lopez did have possession of the gun. He is the one that allegedly stashed it behind the, I think, light pole.
Okay, so when Winston, did you tell me that Winston was
if you look,
sitting on one?
Mr. Winston, or I believe I think his last name is Spence. Winston Spence, I believe he was sitting on a firearm.
And Spence ran with one.
Mr. Lopez, if you look at his other case number, 21 CF 5899, he is charged with possession or carrying a concealed firearm.
Okay.
And the officer writes, he saw a white Hispanic male separate from the group and grab an item out of his shorts and place it on the ground behind an electrical pole. It was a silver handgun. Later, Mr. Lopez advised that he had to carry a firearm for his protection so he doesn't get killed. Mr. Lopez was in actual possession of one of the firearms as evidenced by the officer seeing him with the firearm and tried to
Carry a
dispose of it.
firearm so he doesn't get killed. That's interesting. Okay. All right. And the other thing, Mr. Lopez, the big question right now is whenever you commit a burglary and there's a firearm involved, it technically could be punishable by life. I don't think that these will be punishable by life because I think that the reason the statutes are really created that way, burglary with a firearm, is to allow life imprisonment for people who break into houses with people in them and they have a gun, and there may be other reasons why the legislature made it technically punishable by life, but you should understand that technically it's punishable by life, even though it's burglaries and you're playing with guns.
Yes, ma'am.
And I call it playing with guns because I've represented too many young men who were playing with guns and it went off and somebody died. And it's not fun for anyone. Everybody's life is wrecked.
Yes, Your Honor.
And so playing with guns, we take it very seriously. There's too many people getting hurt and killed out there anyway. And I don't know what your situation is, but the other thing I want to warn you about is that I think that there were probably multiple car burglaries involved. And so if you've ever heard of Chinese water torture where it goes drip, 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 you might get the drip, drip, drip if they find more cases. And they find cases by finding stolen items. And then they file them one after another, after another, after another. So once you get your mother to put a bunch of money up to bond you out and get an attorney, you might find it happens again and again and again. And that's what happens with multiple burglaries. So I'm just letting you know, since you're young, you might not know these things yet.
Yes, ma'am.
And you might want to watch who you're hanging out with,
Yes, ma'am.
unless you like this,
No, ma'am.
or you want to go to prison and be somebody's boy,
No, ma'am.
all right? So, and the state has passionately argued that you should be held no bond. Since you, and I understand that, given the concerns about, I'll set the bond of armed burglary of a conveyance with a firearm at $7,500, grand theft of a firearm at $150, criminal mischief at $150, and then the separate charge, carrying concealed firearm at $1,000. That's 2021 CF 5899. That's going to Division 10. The first one's, I'm sorry, the second case is Division 11. The first one's Division 10. And the public defender is only provisionally appointed. Your mother is welcome to pay for a private attorney and get that lawyer substituted.
Your Honor, state would ask for the condition of no contact with victims, witnesses, or the co-defendants, no weapons, firearms, or ammunition, and no return to this area.
Thank you very much for that. We'll order all that. Thank you. Good luck, sir.
Have a good day.
All right. Mr. Marrera Cardona, sir, thank you.
Good afternoon. Sorry.
Good afternoon, sir. Let's go ahead and appoint the public defender for you on everything that you don't already have them appointed on. And, sir, we have more than one case. We have 2020 CF 14661 in Division 20, and it was a possession of cocaine. You got arrested on violation of pretrial release program in that it was alleged that you had a positive for THC on a drug test. So Judge Wooten set the bond on that at $500 to get back out. In regard to 2020 CT 7676 in Division 63, that was a driving without a license, and the alleged violation of pretrial release alleges that you failed to make some of your telephone reporting calls in January and February. Judge Bigney set that at none. But the offer is withhold time served when you get, that's ironic. Then you have another traffic case, 2020 CT 7947, no valid license, allegedly a failure to appear for pretrial conference. And that one is a bond of $200, but the offer is adjudication, guilty, time served, court costs, and, okay. So on the misdemeanors, you're going to be able to resolve them pretty soon, but you got a no bond on the misdemeanor. Counsel, maybe you can run him into the court for a plea real soon on those.
Yes, Your Honor. We already have his case, and I'm not the attorney on it, but I'm sure I'll email
Yeah, I just,
today, and
I
the
don't,
attorney will be
the
right
idea of that really just seems inconsistent, that she put no bond, but then she put the plea offer of time served, so maybe you guys can run him either back here if you can agree on it. I don't mind taking a plea on it, but good luck.
All right, thank you.
You're welcome. Mr. Mihalovich, right?
Yes.
Okay, sir. This is case number 21 CF 5906. Let's go ahead and appoint the public defender for you. And we have case number 2021 CF 5906 It's in Division 14, and it was in relation to a warrant alleging burglary of an occupied dwelling and count 1 and voyeurism count 2. Judge Jordan set the second one at none until IAs. So he wanted us to look at the situation and also your criminal history.
Your Honor, there's also,
Last conviction was 1991.
he's also been on Social Security disability for the last 4 years, so monetarily speaking,
Okay,
money might be an issue.
all right.
Your Honor, I do believe this has been a repeated offense over and over again per the warrant. The victim has seen the defendant outside of her house multiple times. So I'd ask that you also take that into account when setting his bond. It's not a one-time incident. It's happened multiple times.
Okay, I have to confess, I didn't get this far, so I'm going to have to look at it for a minute. It's been happening on Wednesdays around the same time for the last 3 weeks.
I see Wednesday, April 28th, Wednesday, May 12th, Wednesday, May 19th, Monday, May 10th, May 19th. It's repeated behavior, Your Honor. And the victim has made it known that she obviously does not appreciate the attention and looking in her windows.
All right. Anybody have any idea what it needs for this guy to stop?
I'm sorry?
I mean, I guess you're asking for no bond, and
No, Your Honor, he's entitled to bond.
any recommendations?
1,000, Your Honor. I believe voyeurism is just an M1.
I'm sorry, I can't hear.
She said 1,000,
Your Honor, the way it's charged voyeurism is just an M1.
All right. 1,000, okay,
So I was asking for 1,000.
thank you. So, and what's the burglary part? Did he ever,
He entered the curtilage of her house that was enclosed with a fence.
all right. All right, sir, let's go with 5,000 on count 1, 1,000 on count 2. Talk to your lawyer about it. I understand that there's, SSI problems, and so you're not wealthy, but we're concerned about repetitions of this.
Your Honor, state would ask for no contact with the victim and no return to her residence.
Sir, don't go back there. Don't contact her.
Yes,
Right. Good luck.
Thank you.
Okay. Mr. Nelson?
Excuse me, ma'am. Yes, ma'am, this is me.
Are you Mr. Nelson?
Yes, ma'am.
All right. We're going to appoint a public defender. Did you want to talk to your lawyer about something? I've got several failures to appear, so I'm not going to be able to help you get out right away.
I understand, ma'am. I was just wondering, I have
He has a paid attorney, Your
yes,
Honor.
I have Richard Parker from Mendel Law on these cases. I'm just wondering, why is there a public defender being appointed?
Because, number one, you put 0 on the application for public defender that you didn't have any income. And when we see that you don't have any income, and I know they just give you the piece of paper, but we just assume public defender. And the other thing is that, you don't have to have a public defender if you've got a private attorney and somebody's, taking care of all that. Is that what you want?
I already have one, so I just didn't want to have.
Right, they're going to charge you or your family more for every new case, so just tell me.
You said every new case?
Yeah, every new case, the lawyer charges another fee.
Mm-hmm. No, I understand, but the only new case, so the FTAs,
Is that?
Yeah, you got probably a new case here, okay? Let me
No.
explain that to you. It's an alleged
Felony battery, Your Honor.
felony battery, 2021 CF 5540. So you might not be familiar with the fact that this case is out there because it was alleged to occurred on 20th of February. And so sometimes what happens is
Your Honor, I believe this was from May 11th.
Really?
The warrant that I'm reading, yes, Your Honor.
Okay, so I guess I'm reading the first page of the arrest warrant, and they may or may not have put the right.
No, Your Honor, I believe
Date.
that was using the form.
Yeah,
the
they were
body of the
using a
affidavit.
form, I'm sorry.
It's May 11th.
Understood. Okay, so on May 19th, allegedly a voyeurism.
No, Your Honor. I
No?
believe This is the felony.
No, I'm sorry. I'm tired, Mr. Newsom, and I was looking at the case, the last case. I'm so sorry.
Yes, ma'am, it's okay. I was getting a little scared, that's all.
Oh, I hope that. I guess so.
No, no. I'm sorry.
Let me make sure I've got the right one. So now, but there's some failures to appear.
Yes, Your Honor, there's failures to, I think you had it,
wait
you
a
had the
minute.
wrong warrant.
Wait a minute. I do have several failures to appear, but Mr. Milovich's paperwork is in Mr. Nelson's, and so it wasn't me. But what happened was we had like an astounding number of cases today, and we're having trouble with the paperwork.
And on Mr. Nelson's 21 CF 5540, the beginning of his warrant does say February 20th of 2021, but in the body, it goes into May 11th, 2021.
Well, I'm just happy that I found the right number of, no, might not have it, so I think, no, it wasn't the clerk. I think what happened was, here's what happened. The judicial assistants are gonna print me out the warrants, but I think that we just got overwhelmed today with the number of them, and we accidentally put Mr. Milovich's affidavit for warrant in Mr. Nelson's file. And so I didn't see it, but the clerk's printing it out for me. Okay? Which is what happens when you got 40 felonies in the afternoon. Ms. Nelson, I'm just apologize. We got too many pages today. We got like 40 felonies, and we accidentally put another guy's package in your files.
Ooh.
So I'm sorry,
Okay.
but I'm now looking at the correct paperwork.
Your Honor, I
so-
did speak with Mr. Nelson as a friend of the court. He has been trying to reach his attorney since last night.
He what?
I spoke with Mr. Nelson
What?
as a friend of the court, and he spoke to his attorney. He's been trying to speak to his attorney since last night, trying to call,
Okay,
just to inform you.
all right. They don't always take their phone to bed with them, and they don't always answer it, you know.
Yes, ma'am.
And let me just look at this thing. It's allegedly May 11th. Battery domestic. Verbal with the boyfriend, grabbed her by the arms, threw her around the house, injuring her arm and the left area of her face, and she had bruises and lacerations near her left eye and by her forehead and her upper lip. So that's what that supposedly is.
Your Honor, she went to the hospital. She did have a fractured wrist.
A fractured what?
A fractured wrist.
Okay. All right, so there's that.
Okay.
All right, and so that's a no contact, separate residence. I didn't read it well enough with the 40 cases that I have today to tell you whether you were living there or not, but if you were or are, we'll give you a police escort to get some things out of the house, until a judge hears from both sides and can decide that it's safe. All right? And the state's gonna ask for no guns, weapons. If you have, in fact, any of those, you give those to the custody of the arresting law enforcement agency within 24 hours of your release for safekeeping.
Your Honor, there was also an allegation of drinking. State would ask for no alcohol or drugs without a valid prescription.
All right. Mr. Nelson, I usually grant that when they ask for it, just to be able to move along here. Now, there, for that, that allegation is felony battery, okay.
Yes, Your Honor. Mr. Nelson has a pretty significant history.
Yep, he does. All right. Sir, you got a few things. Let's set that at 2,500. Sir, you got a few failure to appear warrants, which I think you might know about your lawyer knows what to do. In 2020 CF 5474, Division 16, it's a failure to appear on a burglary, grand theft, criminal mischief. For a plea hearing that was supposed to happen on the 7th of May, and that's no bonded in Division 16 for right now. In regard to 2020 CF 7749, it's a failure to appear on a burglary, dealing stolen property, petty theft, and criminal mischief with a no bond. That was the same plea hearing on the 7th of May. So you talked to the lawyer about that, plus the one that supposedly happened a few days later.
Excuse me, ma'am. Like this domestic, correct? They're not filed on me, are they? It's just I've been.
Yeah. So what happens is, first the warrant comes in,
Okay.
and then the state has 30 days to file.
Oh, okay. So it's just okay. That's.
Yeah, it's just in the hopper. We're letting you know about it. Good luck.
Much.
Is this Mr. Newsom?
Bonded, Your Honor.
Thank you so much. Is this Mr. Nieves Rojas?
Yes.
Okay, thank you, sir. Sir, this is case number 2021 CF 5885, Division 11. We are going to appoint the public defender to represent you, sir. They have enough information to at least file the charge of possession of heroin, sir. The bond amount is $1,000. If you bond out, make sure you come back to court for all your court appearances. The state's going to ask for an order that you not do any drugs while you're out on bond.
Right.
Good luck. What is this, Miss? Doesn't look like LaRonda.
Presley, she's in the hospital.
Okay. You want to set this one aside for a minute? Okay. How about, is this Mr. Robillard? Okay, thank you, sir. The case number is 2021 CF 5944. It's in Division 10. We're appointing the public defender. The allegation is sale and delivery of fentanyl in unlawful use of two-way communication device. And it looks like they have enough information to file the charge, although it's 0.5 grams. And the unlawful communication device is using a phone. Is that up at 15,000 now?
Yes, Your Honor, for sale and delivery.
Right. So those are high bonds on that one. And I'll just take no action on the driving license suspended that you're out on bond for because that other bond's
Your Honor, state would request no drugs without a prescription, and also that he comply with 903.046 sub 2 sub F Florida statutes. So if he bonds out, he has to show an affidavit that the funds that he's using to bond did not come from illegal means.
I don't have to do that, do I? This is a small-time guy, it's like a $50 worth. I mean, unless that's required by the statute.
It's in the bond statute, Your Honor.
It's what?
It's in the bond statute.
Is it required? Is it mandatory? I don't think he's a big-time dealer, and he's obviously kind of sick from doing it himself. He's already paying the price. If it's not mandatory, I'm not going to do it. But thanks. Good luck, sir. Mr. Rodriguez? Well, if we stay here long enough, more of them will bond. Is this Mr. Rodriguez? Noel, yes, sir, thank you. Okay, it's case number 2002-1 CF 5896, Division 16. Let's appoint the public defender to represent you, sir. All right, it looks like they have this theory is that you were an accomplice for the other guy, and they can file the charge based on that. Bond amount of the burglary of the vehicle is $3,500, and the grand theft is $150, sir. Don't return to the scene. No contact with any of the victims or witnesses. Make sure you make all your court dates.
State would also ask for no contact with the co-defendant, Your Honor.
Okay. Good luck, sir. Mr. Royal? Is this Mr. Royal?
No, he refused court, Your Honor.
Okay, let's put him to the side. Is this Mr. Santana Ocasio?
That's it.
We have case number 2002-1 CF 5925. It's going to Division 10, appointing the public defender. It's an alleged possession of cocaine. And it looks like they have at least enough information to file the charge, sir. Bond amount is $1,000 on that. If you bond out, make sure you come back to court for all your court appearances. The state's going to ask that I order you not to have any drugs that are non-prescribed while you're out on bond.
Okay.
Good luck. Okay. Ms. Sapp?
Yeah, bonded.
Bonded.
Yes, Willie.
Is this Willie B. Sipp? Okay, thank you. It's case number 2020 CF 5016, Division 15. It was a failure to appear, which means you probably already have the public defender. All right. It was on a possession of cocaine and paraphernalia. It's at no bond right at the moment. It was a pretrial conference on April 28th. And so it says, basically says, don't let him out. That judge wants you to go back to the court before you get out. All right, good luck to you, sir. Right. All right, Mr. Spence, case number 2021 CF 5890, 5900, 5901. Sir, we're appointing public defender for everybody, but the public defender can't represent everybody because you might accuse each other of something, and so ultimately, there will be 4 different lawyers on this case, each representing a different co-defendant. That does create a little bit of confusion up front as the paperwork goes, and shifts around, and the lawyers eventually get appointed. We appoint the public defender initially, but then they just get the process started, but what they really are doing is pulling out of the case and getting discovery started.
Your Honor, as to count 1 being a PBL, I renew my earlier arguments. He was in joint constructive possession of recently stolen property, which substantiates the armed burglary of a conveyance. He became armed while burglarizing the conveyance, which is enough to establish PC for the armed burglary of a conveyance. Given that it is a PBL, state would ask that you hold him no bond pending an Arthur hearing. In this case, there is joint constructive possession and principal theory applies. And they are in possession of recently stolen property. So for all those reasons, state would ask that you hold him no bond on count 1 as it is a capital offense.
Okay.
Your Honor, to that point, you must find proof evident presumption great is, again, as we've stated in the past with the other co-defendants, a heavier burden than reasonable doubt. Just like the other co-defendants, no criminal history to speak of for Mr. Spence. So I would have you consider that in your discretion as well.
And Your Honor, to help keep co-defendants separated, Mr. Spence has the additional fleeing and eluding, and he was the co-defendant that was found sitting on the stolen firearm.
Right. Even though he said that somebody else did the fleeing and attempting to elude, he is the one they ended up finding that driving the car, and it's registered to his mom. And
yes, Your Honor.
He said they pressured him to flee. Okay. So the other mess, sir, there's at least two scary things, if not more. You guys are all young, but it looks like there might have been more than one car burglary. So as I've told everybody before you so far, if they find more evidence of car burglaries, that is stolen property that they later can connect to a separate car burglary, they file them. And so even if you get out on one charge, you could get rearrested because they keep finding evidence, right? Just to let you know that happens. The other scary thing is she's talking about first-degree felony punishable by life imprisonment. And I told one or two of the other guys, to me, I think that the legislature originally intended those to be for like the scary burglary where somebody breaks in with a gun and threatens somebody in the middle of the night. And that's, you can really understand how that would be a life imprisonment type of case. But because of the way the statutes are worded, it can be applied technically to a car burglary where you take a gun. Now, are they going to put you in prison for the rest of your life over that? Probably not, unless they have other good reasons, like they find so many of them, they think you're never going to stop committing car burglaries. But, so it's technically, technically punishable by life. And when those cases come in, we always have to have these long discussions with the lawyers about whether you should be kept at no bond, because it's technically a life felony, even though it's probably not going to be a life felony at the end. So the scary thing is the size of the charge coming in, and also if they find more burglaries and they keep, putting them on you. Only you know how many of those things happened and how many of them they can find, but you could just keep bond out and get put back over and over and over again. That's what happens with a string of car burglaries. Now, and I'm a little concerned about the fleeing and attempting to elude, and I read where, you said the other ones told you to do it, but, you're all like 18 and 19 that I can see so far, so it just seems like, hopefully you grow out of it, but it's serious coming in as an armed burglary, and you have the fleeing and attempting to elude. How bad was that? I don't even remember. how bad that was, because I was reading the other stuff. Began to travel, came to a stop, immediately fled.
The officer, due to agency guidelines, stopped the search and put out a bolo, and the car was later stopped, and the officer
Okay,
recognized.
so it's like 13 minutes after midnight, but 2 a.m. in the morning, they got the kids. Okay, all right, okay, so he literally got away.
The officer stopped pursuit and then
Yeah,
recognized him later.
all right, well, okay, sir. So the good news is there wasn't this fast pursuit, which puts everybody in jeopardy. I've seen so many crashes happen that way. And that comes in at no bond. Also, that one is 2021 CF 5890, Division 16. And I know you told the officer is someone else, but then you also said they pressured you to flee, so who knows what they're going to be able to prove on that. That's a serious charge. I'm going to put that at 10,000. In regard to the armed burglary of conveyance, he ended up with a firearm too?
Yes, Your Honor, the stolen firearm.
All right, when you ended up with a firearm, I think I'm trying to be consistent. I think I put it at 7,500 for the armed burglary with the firearm, 150 for the grand theft of the firearm, and 100 on the criminal mischief. I'm trying to be consistent on these, and if I'm not 100% consistent, I'm sorry, but it's been a long day. And on the carrying concealed firearm, I already hit you on the fleeing and attempting to elude in the other one, so I'm going to call that one $150 bond on 2021 CF 5900AO, and that's Division 19. The other confusing thing is when you come in with multiple cases, they go to different judges for a while, but the lawyers know how to put those back together eventually. It's just a confusing thing at the beginning. All right, so if you do bond out, you're going to have multiple court dates until your lawyers can get it all under control.
Yes, ma'am.
Your Honor, regarding conditions, they would ask for no contact with the victim, witnesses, and other co-defendants, no return to any of the scenes, no weapons, firearms, or ammunition.
Right. She's been asking for all those, and I've been making those orders, so read all your paperwork so you can keep up with that. Good luck. Mr. Ulysses? Thank you, sir. And I'm sorry for the wait, but we had basically so many cases, we're still working on them. We have case number 2021 CF 5927, it's in Division 12. Not seeing a public defender form. Are you planning on getting a private attorney? Your options. Well, your options are, we could just appoint the public defender for now, so they could get the process started where the paperwork is supposed to come from the state attorney, and they can get that started. And then if you're thinking about getting a private attorney, just go ahead and try that, and if you can't, then you've already got one. And if you do get a private attorney, they'll substitute in, okay? Broken glass pipe, powder residue, rock-like substance, tested positive. That's enough for them at least file the charge of possession of cocaine with the bond amount 1,000 and paraphernalia bond amount 100.
Your Honor, they would ask for no drugs without a valid prescription.
No drugs without a prescription. Just say no. That's Nancy Reagan. You guys are too young to know about that. But I always remember that every time we say that to somebody. And that was a craggy finger, too. Okay, there's another case, 2015 MM 215AE. It was an old case out of wow, that was a reckless, reduced from DUI. In Division 84. And it was a failure to appear. A violation of probation. It's sitting at no bond, which is real common on the violations of probation, so it finally caught up with you. But, by the time you get to see the judge, you might get just credit for time served on that and get it out of the way finally. Yeah, let's appoint the PD. All right, At least you haven't been in trouble for a few years.
I just watch my.
Yeah, so the old reckless will catch up with you, and you won't have to worry about that warrant anymore. And you probably get time served on the VOP. Good luck.
Hello, Mel.
Hello, is this Mr. Westmoreland?
Funded, Your Honor.
Okay.
Funded.
Is this Mr. Williams?
Yes, Mel.
Okay. It's case number 2020 CF 13733, and it's a failure to appear in regard to a status hearing on April 28th, and the judge put the bond at $2,000. It's an attempted burglary of conveyance. I'm guessing that he already has a public defender. He does. All right, sir. So
Mel, they dropped that charge.
you thought they dropped it?
I know they did.
All right, so, well, evidently, maybe not. So, look, if you have access to the internet, do you?
No,
You have access to internet?
not really.
Not really. Anybody you know having access, you can look up on the website for the clerk of court and always find out your court dates.
All right.
It's public record, okay?
Your Honor, for the record, that
They
case
had
is still
dropped that
open.
charge, Mel.
It is still open, Your Honor.
Well, see, sometimes that happens, but sometimes it's just wishful thinking, and evidently it's still open. They're all telling me it's still open. Another thing that could happen is that they let you out on a motion that when the state's late on their paperwork
Your
and then
Honor,
they
it
file
wasn't
it.
a,
It wasn't? All right, it's still open, sir. Good luck. Is this Mr. Williams?
Williams.
Oh, is that Mr. Williams?
Your Honor, we
Okay.
just had Mr. Williams.
Sorry, I'm starting to get
Yeah.
tired. Okay. Are we on felony VOP warrants then?
Yes, Your Honor.
Awesome. Okay. This is Mr. Camps.
He refused court.
All right. Let's just roll through it. It's 2017 CF 8263, Division 11. Let's appoint the public defender. It's at no bond status, but we know he's going to see the VOP judge.
We'll waive the appearance as well, Your Honor.
All right, he's going to see that judge soon. Okay, thank you. Is this Mr. DeBello?
He also refused court.
All right. All right, 2020 CF 94500, Division 11. We'll appoint the public defender.
We'll waive the appearance, Your Honor.
Thank you. He's at no bond, and we'll let him talk to the VOP judge within a couple days when he gets there. Did we already do Lopez?
Yes.
All right. Owens?
Yes, ma'am.
Mr. Owens? All right, thank you, sir. Thank you. We have some violations of probation, I think. Case number 2020 CF 4177, Division 10. Let's appoint the public defender on all these. It was alleged that you changed residence and they didn't know where you went, so it's no bond. That was on a dealing in stolen property and false information at pawnbroker charge. In 2020 CF 2707, that's a violation of probation on a petty theft. And that was also basically absconding. I think that was also in front of Judge Mark Blackman. It's at no bond. And then the last one is the 2020 CF 9087. That's a violation of probation on a petty theft third offense, and it's the same basically absconding. So, and so you might have bonded out on a misdemeanor petty theft since then, but I don't need to take any action on it, given everything else you've got going, unless you want to just be accumulating time, credit for time served on that at the same time, if you
Your
figure
Honor,
not, you want.
Okay, bond out? It's a summons. He's never been.
Oh, it's a, thank you, Ted, for telling me that. So, okay, sir, so in 2021, MM 3086, it's just another case that they found that was out there. And I have to tell you, with as many cases we had, I didn't look it up today, so I don't know which one that one is. They're on public record. They, you know, if you know anybody who can look it up on the internet and you've got the case number, they can read you out the factual circumstances on that one. They got another petty theft sitting there.
Yes, Your Honor, it has been filed. It is scheduled for arraignment in June.
Let's go ahead and appoint the public defender on that one also.
Say what? I didn't hear nothing. Say what happened now?
It's
No,
already
no.
been filed on. It's set for arraignment June 8th.
Yeah.
For what?
So, I'm sorry, when I said no action, it was because I thought I already had done enough to him, but it doesn't, it's just a notice to appear. So instead of, I'm not gonna like make him post a bond, but I'm just telling him that he's gonna have a court date and appointing the PD. Okay? Thanks.
So I mean, I don't have no bond, period? You won't give me no bond?
Well, when you get a violation of probation, you don't get a bond, especially in felony court, Mr. Owens. You're gonna have to see the judge on that.
So I have another charge, you saying?
Well, yeah, they found a new little petty theft, and I didn't look it up. I'm just telling you, got enough going on. And I'm sorry, I can't tell you more about that right now. Mr. Pierre Lewis? Yes, sir. Thank you. It's case number 2015 CF 13154. Let's appoint the public defender for an alleged violation of probation in Division 11. It was a grand theft charge. It's alleged that you failed to pay your cost of probation, and also that on September, wait, there's more violations on the third page, but I never get the third page. I'm sorry. It's just not here. Oh, wait, here it is. Okay, in addition to the court costs, there was allegedly a battery charge on April 29th in Seminole County. And so I don't think they would revoke you on the money conditions, but the battery does put you in a VOP status. And it's currently no bond, but you'll see the judge pretty soon.
Okay.
All right. Mr. Stovall? Okay. All right, that's a violation of probation on 19 CF 3996, and it's at no bond. We'll appoint the public defender. There's a 2021 MM 3435 in Division 82. We'll appoint the public defender, find probable cause for providing false ID to law enforcement officer at the bond amount of 500, and also possession of drug paraphernalia with the bond amount of 100. He had also a 2021 CF 5946 in Division 14, a $3,500 bond on a felony battery, and that was a warrant issued by Judge Jordan. Will also require no contact with the victim, no weapons or firearms, do not possess or consume any alcohol or illegal drugs.
We'll waive Mr. Stovall's appearance as well, Your Honor.
Okay, thank you. Sorry if I'm jumping the gun, but thank you for clarifying that for the record. Is this Mr. Thames? Yes. Thank you, sir. The case is 2019 CF 10278, and we'll appoint the public defender to represent you on this alleged violation of probation, which was originally sale of delivered cocaine in Division 14. Allegedly, you got a loitering and prowling on April 17th and a voyeurism charge on April 17th, and that's what violated the probation on the old charge. It's currently at no bond on that because it's a violation of probation, but you'll see the judge pretty soon on that. You want to talk to the lawyer first because you might accidentally say something. All right, thank you. Is this Mr. Irizarry?
Yes, Mayor, Your Honor, good morning. Good afternoon, sorry.
It's hard to tell in here, isn't it? Good afternoon, sir. This is an out-of-county warrant out of Polk County, and the case number is 21MM2378. And it's on a domestic battery, and it's holding you no bond, which is real common for the domestic batteries. They hold you at least until you see the first appearance judge. So Polk County, not too far from here. I don't think they'll pick you up over the weekend, but soon after. All right. And no, they won't leave you in here forever. If Polk doesn't come in time, they'll bring you back. Okay? But you need to go to Polk County. And it's no bond. You can't bond out. You just got to go over there.
May I ask to speak with you?
May you ask what?
To speak with you? Just
See, here's the reason I am very careful about that. There's two reasons. Number one, we had about 100 cases today, but number two, and which is really number one because it's most important, is you are at a really high risk of accidentally incriminating yourself if you say anything at all about your case.
understand.
So, and I basically told you everything I can tell you. There's nothing I can do. So I'm just going to tell you, thanks. Good luck.
You didn't appoint the public defender, did you, Your Honor?
Was I supposed to appoint a public defender? No, because it's a Polk County case, but they'll appoint it when it gets over there at IA's, I think. Do you guys normally, I guess the only other way would be if he doesn't get out right away, does the public defender get involved with that?
Or if you had if there was an out-of-county warrant and then also a charge that occurred in Orange County, we may be appointed for the charge.
All right, he didn't have an Orange County, did he? Okay.
No, it was just an out-of-county warrant. I'm just saying hypothetically.
Okay. All right, is this Mr. Pierre Lewis?
Yes, ma'am. Hello, Judge. How are you doing?
Okay, thank you, sir. Thanks for waiting. We've had a long day.
It's okay. Thank you so much for having me here again.
Look, okay, I'm going to go fast now.
Don't go fast, too fast.
No, I have to, because everybody's on overtime.
Nah, I hear you.
All right, so we have a whole mess of Pinellas County cases for you. Are these all Pinellas?
No, it's just,
they're not.
it's just one.
One Pinellas?
Yes, ma'am.
All right, well, there's one, 2020 CF 1438980, and that was, okay, he's out on
Yeah.
bond,
Yeah.
at $1,000 on that.
Yes, ma'am.
And there's a petty theft. Oh, I'm getting, Pinellas County is written on the top of some of his paperwork, so whenever I see it written all over the top, I think it's Pinellas County case, but some of these I think are local cases instead. That he's out on bond locally on possession of Utalone and also 2021 MO 1921, which is in Orlando petty theft that he bonded out on April 1st. He's got a return date of the 14th of June. In regard to the possession of Utalone, that's a different court, Division 17. Your return date is June 1st on that one. In the meantime, the Pinellas bond is $5,000 on a criminal use of personal ID. And no contact with alleged victim. They will extradite. I'm not sure if they're going to extradite before you deal with your local charges. Is there another one?
Yes, ma'am. I have a couple here, but.
You have a couple here.
Yeah, but I have
The
another.
possession and the petty theft.
Yes,
And
ma'am.
let's see if there's another. Yeah, and so I think you just have the one in Pinellas with a $5,000 bond, if I'm not mistaken, even though there's multiple pages in relation to that. Am I correct? Just one Pinellas? Yeah. Counsel, I don't know when he got that charge, so I'm not sure about.
Say, I would just ask that you take no action, Your Honor.
All right, so we're not going to do anything in regard to your local charges. We're not going to do anything in regard to your local charges. You have a court date on June 1st and June 14th on those. If you bond out on the Pinellas County with the $5,000, make sure you come to your local court dates first.
So I have to bond out here.
You can bond out on Pinellas here, and then
Be
you will
released
have a
here?
court date to go to Pinellas.
And be released here
Yeah.
because I'm at the shelter right now. I'm literally. This is. Okay, I know I can't
Yeah,
talk
it
about that
gets
stuff.
complicated when you get multiple cases, sir.
Yes, ma'am. I understand. I've never had issues like this.
Well, maybe this is enough to get you to make some different decisions
Mm.
in the future. I hope so, because we have plenty of business. We don't need your repeat business.
I know and I understand this. So sometimes God is doing something, you know.
Yeah, well, maybe it's a sign.
I know.
All right, good luck.
All right. Thank you so much.
You're
Is
welcome.
there any way I could have time served or something or ROR, anything?
No?
I tried.
Would you like a hamburger with that?
Oh, no.
Good luck.
All right, Judge. Thank you.
Maybe onion rings instead of fries. Okay. Mr. Rogers?
How you doing?
Okay, sir. Get a little punchy here at the end. We have a Volusia County warrant for you, I think. And it's sitting at no bond because it's a violation of probation on a grand theft charge. So I can't do anything to help you. I'm just telling you, they're going to take you down to Osceola. And that's it, okay? All right, so we just got a couple who failed to, didn't want to come to court.
Yes, Your Honor.
All right, and the first one was LaRonda Presley. And she's in the hospital, I'm sorry. And that was 21 CF 5943, Division 19. Let's go ahead and appoint a public defender if she hasn't already got one.
We'll waive the appearance, Your Honor.
Thank you. That was an arrest warrant signed by Judge Jordan in regard to a petty theft, 2 priors. It's a $1,000 bond on that.
State would ask for no return and no contact with victims and witnesses.
So ordered, thank you. And we have Irvin Royal, and that was 2021 CF 5930, Division 19. We can provisionally appoint the public defender, count 1, possession of methamphetamine, bond amount 1,000, count 2, possession of cocaine, bond amount 150. Looks like they have enough probable cause, appoint the public defender. And
No drugs or alcohol without a valid prescription.
no drugs or alcohol. He evidently was out on bond.
I believe he's out on ROR in that case, Your Honor. By the way, we waive Mr. Royal's appearance.
All right.